Yes. This side. This side. Okay.
May I please also?
Yes.
My lord, I like to mention two unlisted IA for listing today, my lord. My lord, this is just for implement only, my lord. In item number 17 and 18, my lord.
In 17 and 19.
Yes, my lord, it's this.
Okay.
All that. May I lordship, I like to mention item number 19 with the consent of order 40.
Hmm.
Leading counsel is due to personal difficulty, he could not attend today. So, lordship, yesterday my senior has mentioned this matter on 6 April.
7th April, I guess.
7.
Yes, 7th April. That is on Tuesday.
Lordship, another date may be given because this matter is part heart matter.
When do you want?
8.
Eight.
8. 8 is fine.
Okay.
8.
On the, it's a joint prayer only.
Yes, joint prayer.
Joint prayer made by both the Land Council appearing on behalf of the respective parties.
Oh, my, just it's their prayer. I'm just for
Okay,
presence.
Mr.
BCO on behalf of T Tapak.
Land Council. This, you are mentioning item
19th.
19.
Yes, lordship.
Tapak is there
And Tapak is,
for the respondent.
yes, lordship.
Okay. So Tapak is out of the station.
Yes, lordship. Due to his
Land Council submit that the conducting council for the respondent is out of the station, therefore pray for adjournment, to which the Land Council Miss
Artakam.
Land
For-
Council appearing on behalf of the petitioner is no objection. Prayer is allowed. Prayer allowed. As requested by both the Land Council for the parties. List this matter on 8 April.
lordship, it's a part heart matter. This honorable court, part heart matter.
Part heard by this court.
Yes, lordship. Another date may be given. After 6.
After 6.
Yes.
After 4 weeks.
Yes.
Okay.
Which is what is the date?
After 4 weeks.
After
Yes,
4
ma'am.
weeks. My job like.
Much more.
My lord. My lord,
Yes.
I'm praying for listing of one criminal petition 216 of 2025, my lord, for tomorrow, ma'am.
It's pending before this court.
Yes, ma'am.
Criminal petition
Yes.
tomorrow.
Yes, ma'am.
Okay.
May I please, Lordship. Lordship, I'm praying for listing of one matter tomorrow, Lordship. It's a pending matter, bail application. Bail application 18 of 2026 and bail application 19 of 2026. Lordship.
Okay.
Okay. Tomorrow, Lordship. Deeply obliged.
Item number 1. My lord, the petitioners and the respondent are siblings. The respondent is the eldest among 4 brothers. What happened, my lord? The respondent, who is the eldest among us, he is trying to, my lord, change his surname. And while trying to do so, he has approached the customary court. But the customary court, instead of before that, they all are from this from Tata Mori village under Gaisi circle, and Tata Mori village has its own Gambura, who has the jurisdiction. So therefore, when he approached the village authority,
For changing
yes, changing his surname.
surname, he
Yes.
approached the Gambura.
Yes, Gambura, to hold the Kaba, to hold Kaba. So the Gambura, he, instead of conducting the Kaba in village level,
Saying what? It's not a complaint,
yes,
seeking approval from the Gambura.
yes. In fact, he was trying to change his this surname from Gibi to Richi. So that was
Whether Gambura is authorized.
no, that was opposed by the rest of the brothers, the petitioners here. There are three petitioners, and the respondent is the eldest among all four brothers. So
Where he tried to change? In what manner? How? He tried to change and that's why.
historically, he might have some this historical background for
Okay, now
changing-
where he wanted to change?
He want-
The service book,
No,
where?
all correspondence
Okay,
we made.
he want to declare publicly.
Yes, yes. So he tried to declare, and he was claiming that I am not Gibi, but rather I am Richi. So therefore, these rest of the three brothers lodged a complaint before the EAC Gensi.
Hmm.
That no, he's our own brother. He's the eldest among us. We are all Gibi. How he can change his surname from Gibi to Richi? So therefore, on being lodged complaint by rest of the three brothers, the petitioner here, EAC issued an order for holding Keba. So that Keba was supposed to be held at Tatamori, but the head Gambura of the Tatamori village, he invited Gamburas from this Sibriti area, Gensi Circle. Gensi Circle has as many as more than 14 villages. From all 14 villages, Gamburas were invited to be the jury of that Keba. So that was, and that Keba was held, but the petitioner, they approached this honorable court, challenging the Keba decision, whereby,
Keba decided,
yes, in favor of the,
okay, for
Respondent.
changing
Respondent.
his surname.
yes. So therefore, these petitioners, they had once challenged that Keba decision by filing CRP. The CRP order also I have an
Now, changing of surname
yes,
by someone, are you affected?
yes.
How?
But- Because we are brothers, if we are giving,
Hmm.
rest of the petitioners, three brothers,
Hmm.
they are still giving.
Okay.
And they originally, in fact, by blood, they are giving. By concocting these stories by the respondent, he was that he should change his surname from Gibi to Richi. So the problem is that if
Is he also insisting you to change?
no, but we are from same this biological parents.
Okay.
He cannot be Richi. Rest of the brothers, they are Gibi. Then how can the private respondent alone can change his surname from Gibi to Richi? That is obviously going to affect us. Because he is the eldest among,
Is he
Four.
claiming that he is Richie by blood relation?
yes, he's claiming that. So Now-
Who can decide? If he is claiming that he is a blood,
that will be in fact
Richie.
decided
Hmm.
by the villagers of Tatamori and the village authority of Tatamori, because they were given birth here at Tatamori. Their parents were from Tatamori. There are this Typodians Gibi who are these villagers of Tatamori.
what was the
So they know-
what was the basis of his claim? Basis of his claim that he is Richie or what?
Richie, yes.
Richie.
Yes. From someone, he might have heard that he actually belongs from Richie. But that is, of course,
Okay, what
is the subject matter to be decided by the village level Kaba. We are not saying that village level Kaba should not decide this issue.
Okay.
We're on,
So the village Keba can decide this issue.
yes,
Okay.
but so therefore,
Hmm.
once when he was claiming himself to be the Richie, instead of giving clear. So we lodged a complaint before the EAC. EAC issued order for this conduct of Kaba. That Kaba ought to have been, my lord, this village level Kaba, but instead of conducting village level Kaba, there was a circle level Kaba. So that was challenged before this honorable court, and ultimately that CRP is allowed, and matter was remanded back to village authority for this taking decision. So basing on that, the village authority of Tata Mori ought to have decided this matter. But again, despite the direction from this honorable court, that if agreed by the order of this honorable court, every person can approach the appropriate forum. That is, appropriate forum is the village authority of Tata Mori. But the head Gambara of Tata Mori, my lord, may kindly see the Parwana, my lord, at page number 23.
You're challenging decision of Kaba decision,
Yes, this is of course ex parte decision,
ex parte.
page number 23. My lord, before that, my lord, let us come to my lord, page number 18. This is the my lord order passed in CRP 9 of 2023, where the petitioner had challenged the order passed by the circle level Kaba, and that was allowed. My lord, may kindly come to page number 20.
Yes.
I'll skip rest of the paragraphs. Page number 20, parasis of the judgment. Mr. So's learner for the petitioner submits that head Buraj and political interpreter of Gaisi circle has no jurisdiction and authority to conduct the Bango level Kaba. As the parties, the petitioners and the respondent, being natural brothers or residents of Tata Mori, where the Gambura are appointed for that village and authorized to take up the disposal of the village. Therefore, he submits that the head Gamburas and political interpreters of the Gaisi circle do not have the authority to decide the dispute between the petitioners and the respondent who are the residents of Tata Mori village under the jurisdiction of village authority of Tata Mori. He further submits the circle level Kaba is not recognized under the law. Therefore, the decision is nullity, and as such, he phrased that the matter may be remanded back to the village authority of the Tata Mori village to decide the dispute. Mr. N. Learned Counsel for the respondent fairly submits that under the law, there is no recognition of circle level Kaba. Rather, the village authority are appointed in the respective village where the disputes are to be resolved by such village authorities of the particular village. Therefore, he submits that the matter may be remanded back to the village authority of Tata Mori village to decide the dispute. I will skip right. Undisputedly, the circle Bango level Kaba is not recognized authority under law. Although as a matter of practice, village authority can be constituted to decide a particular dispute if the parties are of different village for better administration of the dispute resolution. However, it will be permitted to the village authorities of the different village to take up the dispute when there are village authorities appointed for a particular village. On Procedural Bango level, circle level Kaba decision that is so and so, it reflects that impugned decision has been rendered by the village authority of different villages pursuant to the constitution of circle Bango level Kaba by the extra assistant commissioner Gaisi. Since the village authority have been appointed for the Tata Mori village, the village authority, much less the political interpreters of the Gaisi and CVS circle consisting of different villages, would not have any jurisdiction to decide the dispute. Under the Assam Frontier Regulation 1945, the village authorities are appointed under Regulation 5 for a particular village.
Okay, what is the direction here?
The direction is that, my lord, 11 is having considered that the improved circle Bango level Kaba decision that is so and so, having been passed without jurisdiction by the village authority of different villages under Gaisi and severity, including the political interpreters, I am of the considered view that the said improved circle Bango level Kaba decision so and so is not sustainable under the law. According to the same set aside request, parties may approach the village authority Gambura of Tatamori village for resolution of the dispute as the petitioners and the respondents are brothers and permanent resident of Tatamori. The civil division petition is still allowed and disposal. Now, therefore, after that, this is next page is the Parwana. My lord can see from the Parwana. Parwana dated 4th February 2026, page number 23.
So according the party approached the village authority again.
Yes, not, my lord may kindly see the constitution of the Kaba jury, my lord. My lord,
Page,
page number 23, my lord. Members of the jury, page number 23 and Excel 2.
Hmm.
My lord, this is for Kaba with regard to changing of surname, but the respondent.
hmm,
Let me kindly see the Kaba members, my lord. Tata Mara, number 1. He is the head Gambura, President Gensi Circle. Sri Mombri Carlo, GB, General Secretary. Rikmar Doke, he is SGB of Doke.
so this is in vernacular. So where the
Oh, type copy is at page number 25, mother. Translated copy.
okay.
May I read the contents?
Yeah, okay.
Sri Tajum GB, son of
Okay.
has
So your objection is to the constitution of the
Kaba members.
members.
Yes, because they are from other villages. And the direction of this honorable court in the earlier CRPC, it is very clear that the village authority of Tata Mori village will decide the matter. In violation of the order passed by this honorable court in the earlier CRPC, this Parwana has been issued. Against that, my lord, at page number 27, we have filed representation, the petitioners.
Hmm.
On 14/2/2026. We are in receipt of the Kaba fixed Parwana to conduct village level Kaba to resolve the pending surname change from Gibi to Richi in respect of Sri Henjum Gibi. Yes, sir. You have referred the order passed by the Honorable Court, Itanagar Permanent Place of Guwahati High Court on 3/2/2025 and caused this revised Parwana, white Parwana report number so. You defied above the Honorable High Court order repeatedly once on 3/11/2025 and again on 4/2/2026. Why? Because these Parwana of yours are not village level Kaba, but a Bango level Kaba. Most of the SGB, GB members, jury members are not from Tatamori village. So also other public members to educate above dispute. You are quite aware that we are consanguine brothers of Sri Henjum Gibi living in Tatamori. Our matters will only be understood by Gibi and Taipodia, people of Tatamori and their offsprings from us, well, Tatamori, but not by Mr. A or B of other villages. Yes, sir. You are the head Gambura of Tatamori village
Okay.
and
So he raised objection. What
yes,
happened?
all of the 3 petitioners.
Oh, 3 petitioner.
Yes.
Petitioner are the person who wanted to change their
No,
surname
respondent, my lord.
from respondent.
Yes.
Okay.
Petitioners,
Petitioners are still Gibi.
yeah, still giving. They are the real brother of this respondent.
So respondent started writing as their surname is Richi.
Yes.
Okay. So
Now,
what happened there?
Thereafter,
Thereafter
my lord, at page number 23,
decided ex parte.
no, my lord. Apart from this representation, there is a advisory that was, my lord, written by Advocate Kembo Bagra, who is the legal advisor to Gamburaj Association of Arunachal Pradesh. Against this Parwana, even the advisor, legal advisor Gambura Association of Arunachal Pradesh has also
Hmm.
written a letter advisory to the head Gambura of Tatamore. Let us see what he has written. A client named Sri Sigam Gibi of Tatamore has come to me to seek legal advice in regards to refixation of Taba Parwana fixed on 16 February 2026 at Tatamore village for settlement of the dispute in regards to surname dispute that fixed by you. Whereas Sri Sigam Gibi has furnished a copy of the refixation Parwana that issued under your office. That I found the Parwana as a defective, as because while conduct the Kaba, only village authority of Tatamore village is having the jurisdiction to become a Kaba jury members, and village authority of other village are having no right to sit in the Kaba as Kaba jury members. That the government has enacted the Arunachal Pradesh Civil Code Act 2021 and the Assam Frontier Regulation, Administration of Justice Regulation 1945, and from time to time it has been amended. And it is pertinent to mention herein that on dated 13 April 2023, the Assam Frontier Administration of Justice Regulation 1945, Amendment Act 2023 has substituted the sections 24, which stated that like any party aggrieved by a decision of the village authority may appeal within 30 days before the village authority, village territorial customary court. But the present case is going to be conducted like inter-village territorial customary court because the members like Sri Tatamara, HGB Gensi, Tamengom HGB, and GB like Sri Nyapagmara, village Big Kari Taipodia, HGB Nilok, Sri Moga Taipodia, GB, and many more GBs have been made as Kava members which are having no jurisdiction to take part in the said Kava, which is also null and void.
Okay. Then,
Then thereafter, despite all this representation and the advisory issued by the legal advisor, the head governor of Tatamore, he has passed the ex parte decision in the absence of the petitioners. Say, declaring that henceforth the respondent will be known as Henjum Richi, but not Henjum Gibi, thereby endorsing his claim
Okay.
of his surname as
will issue notice?
my lord, yes, notice may go, but my lord, as it is apparent from the record that it is apart from being ex parte, the Kaba decision that has been taken by this Bengal level Kaba, maybe this state.
So this is revision.
Yes.
Okay. This civil revision under Article 327 of the Constitution of India has been filed challenging the ex parte order dated 16/2/2026 passed by this, you call it Bango level,
Yes.
but they name it as a village level.
But then your lordship has seen the Parwana, my lord. List of the members, my lord, who is summoned for the Kaba.
By the they said which kebab village they said
They're
according to
saying
them in the Parvana.
in the Parwana, my lord.
They only say there is a village authority of Tatamori only.
Yes, yes.
Village authority Tatamori village, Genchi, Lower Siang. Why you have named it as a Bango level? Because they said it, the order was passed by the Tatamori village only.
My lord, therefore, my lord, this is Bango level kebab because from the
They, They didn't say that
Procedural of
it's a
the
Bango level
Parwana.
Keba.
They are not saying that.
It's your allegation only that it's the composition is Bango level, not the village level.
Yes, my lord. Composition itself is this Bango level, my lord. On the basis of this Parwana only that this impugned order has been passed, my lord.
Hmm.
We have sought for my lord refixation of the debt, where only the village authority of Tatamari will adjudicate the matter. But despite that, the head GB of Tatamari went on to decide the issue.
On the ground that the composition of the Keba is of the circle level, according to
Yes, my lord. Yes,
circle level means
Gezi circle.
Bango level.
Bango level, yes.
Bango level is a circle level.
Yes, it is.
Okay,
almost
Bango
equivalent,
rock
yes.
circle level, huh? And on the ground that the composition of the Keba for decision of for decision is larger forum consists of Bango level stroke circle level who the which doesn't have the jurisdiction under the law staff. The Law Council for the petitioner further submits that earlier the dispute submits that the dispute falls within the jurisdiction of village authority of Tatamori village and not under the jurisdiction of the Bango level or the village authority of Gansi and Sibe circle. Is it? Gansi and Sibe circle also involved here.
Yes, not only that, my lord, even the GB of this Likabali were, my lord.
Gansi,
some
Sibe circle, and where is your allegation that?
allegation, my lord, in the advisory itself, my lord.
Okay, that's fine. Which is a circle Bango level, huh? Stop. Fair.
My lord, it would be better if from different circles
Okay.
If- is recorded like that.
Not under the jurisdiction of the different, not under the jurisdiction of the different village and circle is constituted by the village authority.
Yes,
Okay. Okay. The Land Council for the petition of further submits that earlier. This court in CRP 9/2023 this code by an order dated 3/2/2025 in CRP 9/2023. So earlier order was set aside.
Earlier order. Yes, my lord.
Mm.
Set aside in this earlier CRP. That is at page number 22, my lord.
The decision of the Bango level Keba dated 21/2023 was set aside on the ground that it was passed without jurisdiction by the village authority of different village under Gansi and Sibe circle, including the political interpreters, instead of settling the matter by. Now, what was your village? Tatamori village,
Yes.
and directed the party and remanded back the matter, directing the party to approach the village authority of Tatamori village for resolution of the dispute. However, despite such direction of this court, the mail was conducted in a manner similar to the Bango level by involving different village authorities and Gaumbras from outside the territorial jurisdiction of the Tatamori village,
Yes, my lord.
which is contrary to the law and beyond the jurisdiction of the village authority. Issue notice. Record need to be called for? Call for the,
My lord,
okay, record. The petitioner shall take steps upon the respondent by speed post as well as by usual process within 3 days, 3 working days from today. Stop. Para. In the meantime, the operation of the impugn. Where is your prayer?
my lord, page 11, my lord.
Okay, ex parte Keba decision dated 16/2/2026 passed by the village authority of Tatamori village shall remain stay till the next date of listing. Okay.
Much obliged.
Matter number 2,
Yes.
This is a joint application filed by the petitioner, whereby the petitioner is invoking the section 528 of the BNS. For the crossment of FIR dated 18/4/2024, GR number 19/2024, registered under section 66E of the Information Technology Act. The charge sheet number 13/2025 dated 6/5/2025 and the order dated 25/6/2025, whereby the cognizance has been taken by the learned CGM.
Okay. CGM Alo.
In terms of, yes, Lord, in terms of deed of settlement agreement entered by the petitioner.
Okay. Let us see the FIR where.
Your Lordship, a fire, your Lordship will find it, page number 32. And type copy is
Page 30.
2, your 2.
Hmm.
Is the type, FIR copy, and the 34 is the type copy. 34 is the type copy.
Okay, the earlier FIR was withdrawn.
Yes, your Lordship.
Okay.
Before the.
And where is the charge sheet?
charge sheet, Your Lordship will find Your Lordship
36.
36 onward. Page 36 onward.
Effective 43.
Charge sheet filed on,
And operative portion is page number 43
which means
onward.
charge sheet,
Charges is dated 1/5/2020,
1,
5/5/2025.
okay, yes, 5, 5.
Page number 43.
Okay, this was the same section.
Yes, Your Lordship. Only the section.
Operative portion is
43.
43.
Yes.
The offense is under section,
66E of the Information Technology Act 2000.
okay,
And the maximum punishment in this offense is 3 years or with fine.
okay, where is the cognizance order?
Cognizance order, Your Lordship will find.
Hmm?
Your Lordship. We have at page number 96, Your Lordship. Order. Sorry, Your Lordship. Not Your Lordship. Sorry.
68. No, no,
The order, page number 86, Your Lordship. Cognizance order. Order dated 25/6/2025. Page number 86, annexure 4.
okay. When it was June,
25/6/2025. Cognizance was taken.
okay, where is the agreement?
Your Lordship, it's fine is annexure 6, page number 90.
Okay,
Deed of settlement agreement. In this case, Your Lordship, petitioner number 1 has been already compensated. Your Lordship.
what way, by what way?
Your Lordship will find it undertaking, Your Lordship.
Okay,
Last page 101, Your Lordship.
100,
1, Your Lordship, page number 1, deed of undertaking, Your Lordship. This is the subsequent deed of undertaking as well agreement, Your Lordship.
okay, thereafter also,
Yes, Your Lordship, thereafter, after the deed of settlement agreement, in this deed of undertaking, Your Lordship, it is specifically mentioned that and after the receiving the adequate monetary compensation from the first party.
Hmm?
Your Lordship,
Sarah?
page number 101, Your Lordship.
Hmm.
And
6,
paragraph 6.
Okay,
That in terms of the deed of settlement agreement dated 22/8/2025, and after receiving the adequate monetary compensation,
okay, monetary compensation also given.
he has been adequately compensated. So I'm praying for the enforcement of the fire.
You have,
I don't have any objection. In fact,
That cannot be
this
also.
is,
Ah.
this matter was on the previous occasion also, this matter came up, Your Lordship, on the ground of merit, Your Lordship.
okay,
But then,
but
they-
now
they-
since
they-
they have come in,
yes, they withdrew
agree.
it, and
can
in
we
fact,
dispose of them?
yes, court has
Okay.
suggested that it comes out of marital
Okay,
issue.
okay. Out of meritor only.
Yes, out of marital, and in fact, the court has
Right.
issued that it would be better if the parties come to settle.
Okay. Heard Mr. Ibam, Land Council for the petitioner. Also heard Ms. Jenny, Land Edison PP for this. State respondent. Okay, just a minute, huh? Let me just clarify the party. Petitioner number 1 is informant.
Yes, informant.
2 is accused.
Yes.
Yes.
Okay, I'll dispose of. Okay,
Your Lordship, may I please one the thing, Your Lordship, one criminal. Okay, Lord.
What?
Then there was a
This-
connected matter pending before the.
There was,
Maybe-
there was another matter pending between the same parties.
Okay,
There was a counter FIR that, I've just asked him that it can, because the court has passed an order stating that if this, since this matter was pending in the Lok Adalat. So once this matter is,
This.
dealt with, that matter may come up.
okay, that matter is also pending before
Yes,
this
sir.
court.
Finally, that matter will be listed on 23rd of.
Okay, in that matter also whether the party has
Yes,
agreed.
Yes, that's a joint petition.
Okay. Then we'll dispose of that also. Let it,
It may
Um,
come up tomorrow.
Tomorrow it can be done. tomorrow.
He'll have to.
you have to
see
mention,
mention.
you have to
I'll
give the number.
detail by today itself.
Hmm?
I'll give the detail of the case.
No detail mention. Monday.
Monday, you
Monday.
make a mention, we'll get it listed, mention tomorrow,
Okay, yellow.
we'll get it listed after tomorrow, on Monday.
Yes.
Okay.
Much obliged.
Oh,
Item number 3,
Your Lordship, I humbly seek permission to withdraw this present petition, Your Lordship.
criminal
Some
petition,
correction, Your Lordship. Your Lordship,
this criminal petition,
yes,
is a joint petition only,
yes, yes.
why you want to withdraw?
Your Honor, Your Lordship, the petition, the document has to be annexed, but the document is missing, Your Honor. The final report is missing.
What document?
The final report, Your Honor.
No, Lordship, actually what happened, Lordship, here, Lordship, the charge sheet has submitted, Lordship. The charge sheet, they have annexed charge sheet, Lordship, and the final form, which is forwarding of the charge sheet. But here, what is, he stated in the paragraph 3 that final report has submitted, which is where the.
Final,
has-
the
Yes,
police
Lordship.
has submitted final report.
No, Lordship, actually charge sheet, Lordship, they have,
Check.
wrongfully, they have written here as a final report.
Okay, okay. Okay. Mr.
Pitan.
This is a joint petition only,
Yes.
Yes, Lordship, only little correction, Lordship.
okay. Then counsel for the petitioner. Submits it. He may be allowed to withdraw this criminal petition with liberty to file afresh after making necessary correction. The prayer, no objection.
No,
Okay, has not been objected to by the line additional people for the state staff. According to the prayer is allowed, this criminal petition is dismissed on withdrawal. Okay,
I'd like
with liberty as prayed for, huh? Okay.
item number 4,
Yes.
Date of the letter, going for the agreement of this matter, which is something.
Okay, no objection. Mr. Ibram, Land Council, appearing on behalf of Kate Asso, Land Council for the respondent number,
Sole respondent.
sole respondent, praise for adjournment of the matter. Why adjournment?
Out of the state.
Okay, Ibram, Land Council, submits says, Mr. Kate Asso, Land Council for the respondent is out of the station, and therefore he prays for adjournment of the matter for
4 weeks. then.
4 weeks, to which Mr. Aringo, Land Council for the petitioner has no objection. Prayer allowed. List this matter after 4 weeks.
Your interim is the interim.
The interim order passed earlier shall continue till the next date of listing. Okay.
Deeply obliged.
item number 5,
Yes.
petitioner site not present, Lordship. President, petitioner site is not present, Lordship.
Not present.
Not Lordship.
Okay. So. None appears on behalf of the petitioner on call. List this matter next week.
Lordship, I'd like to.
item number 6,
I'm for the appellant, Your Lordship.
Hmm.
Your Lordship, in the appeal under 173 has been filed for under MV Act. We are challenging the judgment and the order dated 18/12 of 25 passed by the Tribunal MACT Bomdila West Kameng. in MSCT case number 19 of 24. It's in annexure 1, page 13 is the judgment passed.
Okay. You are
VT Gurung, Your Lordship. I'm for the appellant, the claimant.
claimant,
Yes, Your Lordship.
challenge for what?
Your Lordship, the facts of the case is that on 13/10/23, the deceased father of the claimant, one.
Okay,
late Kapoor-
challenging on what ground?
Your Lordship, my grounds are on page number 6. Your Lordship, the tribunal
Paying
has
for what?
educated upon the claim petition under section 164 of the MV Act 1988 and appreciated the evidence presented therein.
So it was dismissed.
Yes, Your Lordship. It has been treated as a criminal trial, Your Lordship. However, during the pendency of the case, the charge sheet was not submitted. Now the charge sheet is completed and on page number, Your Lordship, 52.
Let us see the operative portion of the judgment. Yes.
Page 24. Para 25.
Okay, your ground is? Where have you stated the ground?
Page number 6, Your Lordship.
Page?
6 of our petition.
Is it accident or death case?
Death case, Your Honor.
Sorry, injury or death case, okay. Okay. Mr.
VT Gurung, Your Lordship.
Allow me counsel for the appellant. Sir, this is an application filed under section 173 of the Motor Vehicle Act 1988. Challenging the dismissal of the challenging the judgment and order dated 18/12/2025 passed by the learned tribunal MSCT Bomdila, West Kameng District in MSCT case number 19/2024, whereby the claim petition of the appellant has been dismissed. Staff, the appeal is admitted. Issue notice. The appellant shall take steps for notice upon the respondent by a speed post as well as by usual process within a week from today's start. And then call for record, Call for the file for record, Then notice, okay. Steps within a week from today. Okay. List is matter after 4 weeks.
Obligation.
Okay.
Item number 7 and 8.
Yes.
This is an application under section applicant under section 42 of BNSS Lordship for releasing the accused who was arrested on 13/11/2020 and behind the bar since then. The accused is the name accused behind the bar since 13/11/2020 Lordship. Moreover, for more than 5 years have completed.
More,
More than 5 years have completed.
5 years.
Yes, Lord. And trial is going on. And now the evidence is before the sessions of EPR. And Honorable Supreme Court have granted bail to the main accused Lishironi, Bhai order dated 29/2020, 5 in BA number 66 of 2024 passed by the honor in serial number IA 74506 of 2020 application for permission, IN number 54250 2025. And another two accused already granted bail. Accused Tayatsumi have granted bail, and another co-accused, namely Kapanglite Lawang, he is also granted bail by this honorable court on 13/11/2025.
Okay, the offense is under,
Under TTO 2 120B.
okay. So what is the stage?
This is trial stage, lordship, evidence stage.
How many prosecution witnesses has?
22 lordship. And since then,
What is-
16
how many-
5
total how many
2020
witnesses are there?
lordship.
43 witnesses are there.
43. Out of 43, 32 already examined.
22.
22 have been examined.
Okay, 10 remain.
Witnesses have been recalled. And the last date, that was on 3/3/2026. It was called for cross of Tayachumi, which was declined by the parties. So one we can drop now. So recalling witnesses, there are left with 5.
No, 4.
Now, total, how many accused persons are there?
Total, there are accused 6 accused persons.
6,
Yes, one have discharged. There are 7. One have discharged.
one
And,
discharged. 6,
uh,
out of 6, how many are on bail?
3.
3 on bail.
3 on bail and 3 in judicial custody. Tine Khoang also in judicial custody, and Datang Suang and Dramir Khoang, they are in judicial custody. The allegation against the Tine Khoang is that he is,
The present petitioner,
yes, lordship. BA number 08, lordship.
08.
08.
Hmm.
Item number 8.
Hmm.
The present accused petitioner involved in the case is that he come to Hotel Chopincha from Khoncha and stayed hotel for 3 days. And the allegation is that he have received an amount of 2 lakhs from accused Lishironi and brought to his Khoncha place. And next on 30/10/2025, the brother-in-law of accused Kapanglite Lawang have carried an rupees 5 lakhs rupees to Khuncha through his Jailo vehicle, as he is the driver, as the accused PW number 5, he is the driver of the vehicle who have brought the money to Khuncha. But as per statement of the prosecution witnesses and court examination, it reflect that the bag or the parcel which was brought by the PW 5 Sanglang Moang was the pamphlets and poster of energy dingles made it in a statement of PW 5, page number 118.
No, tell me one thing, whether he was present on the spot at that time of incident.
No. No, lordship.
Okay, only because he has received money.
Yes, but as per search sheet, the allegation comes that the accused Tine Khoang have received an amount of 5 lakhs. But in the seizure list, I have annexed here it as an excerpt. But in the seizure list, only 4,000 rupees was recovered. 500 notes, 8 pieces of 500 notes. I have annexed it in annexer annexer 9 lordship, seizure list by annexer by number 3 of 2020, dated 13/11/2020. Page number 179.
4,000 was seized.
Only
When?
on the date of arrest, lordship. 13/11/2020.
He was arrested after how many days of the incident?
After 8 days
From where?
from Khuncha.
Okay. Okay, just a minute. Then, have you gone through the record?
Yes, Your Lordship.
Okay, what is the allegation against the president?
Your Lordship, the allegation, it's that this person was engaged to hire the person who was in the car and who has executed the murder, Your Lordship. He has also arranged for the vehicle to get them from the
Present
place.
accused.
Yes, in present case, get them from the village. He was also involved in the meeting that was conducted in the hotel, planning for the murder, Your Lordship. Your Lordship will come to page number 47, Your Lordship.
Post number 47.
47, Your Lordship.
This is the
42, Your Lordship. I'll just wait a second for me. If I may read from the third paragraph, Your Lordship.
42.
42.
Yes.
During investigation, a WT message was sent to OCPS Khonsa to apprehend 3 accused persons, namely Kapeng Lete Lowang, Demrit Khoyang, and Tane Khoyang, who is the present applicant herein, who were
Which
involved.
one is present?
Tane
Tane
Khoyang.
Khoyang.
Tane.
Tane Khoyang, who were involved in the case and were learned to be hiding at their native village as per source information and their mobile PTL. In pursuance of their requisition on so-and-so at around 1:40 hours, Khonsa police apprehended other 3 co-accused, namely so-and-so, from farmhouse of Tane Khoyang. Your Lordship will see that he has also, even after the FIR was lodged, he has also shielded the other co-accused in his farmhouse, located at a place called Jungle Camp, Pulung Village, so-and-so. They were apprehended from the same place.
So
where
these other name which has been named here,
yes,
they were
They-
in the
they all-
farmhouse of the present accused.
yes.
Yes.
Well, after
Okay,
the
so
FIR was
what are their names?
Kapwang Lete
Kapwang.
Lowang,
Okay,
Demeret
then
Khoyang.
wait, Khoyang. Tane Khoyang.
Your Lordship will
Two
also-
of them, two of them
Two of them. Your Lordship
from the
will see.
farmhouse of Tane Khoyang.
Yes. Demrit Khoyang is the one, is the driver who has executed the. I'm the driver, I'm Datam Soya. Oh, yeah, Datam Soya. I was.
Samir
I
Kang is
deeply
not
apologize.
here in petition, Your Lordship.
Both of them were there,
Mhm.
present, Your Lord. He's not a driver, but then he was the person who has.
Who was the Kapwang
Little Lawang.
Lete Lawang was?
Yes,
He's
He
on
is on
bail.
bail, Lordship.
just a second, let me finish.
Okay, and Demret is still inside.
He's still inside. Demret is the one, Your Lordship, I'll just apprise Your Lordship about the incident, Your Lordship. Once the plan was made for the murder, Your Lordship, the victim was taken to the farmhouse, Your Lordship. The driver was arranged by the accused herein for a certain period to execute this murder, Your Lordship. This driver has called out the other person on the day of the incident, Your Lordship, saying that he is a mystery, will be taking him along to the farmhouse of the victim, Your Lordship. Now, on the way is when the execution of the murder took place, and this person who was being shielded by the applicant herein and the driver had executed the murder, Your Lordship, inside the car.
No, Lord.
Just a second.
No, just a minute. So,
Now-
who executed, is their name here?
It's driver Datang Suyang, one of the driver who is in respondent number, applicant in item number 8. Item number 7. And this-
Seven.
Yes. Damrit Khoyang, Your Lordship. Now,
No, just a minute.
now if I may take Your Lordship to page number 71, Your Lordship.
Page 71.
I'll just apprise the court about the entire gist of the case, Your Lordship. If I may read, Your Lordship, page 71.
Seven, no, just a minute. Yes,
If I may read start from paragraph 2, Your Lordship.
yes.
Further, in order to disguise their plot on 5/11/2020 morning, Roni mobile number so-and-so called his staff Vijay Biswas and asked him to hand over the cash of rupees 10,000 to new driver Datang at Lekki Complex House for one mystery waiting at Bagi Tinali. Accordingly, Vijay collected the cash of rupees 10,000 from Sri Marto Ingo and went to Leji Complex, Naharlagan. There he met the deceased late Meena and Datang in the kitchen. Vijay informed the deceased that Ronnie had asked him to hand over the cash to Datang for one mystery waiting at Bank Bagetinali. Meanwhile, Ronnie called Vijay and asked him to hand over the phone to the deceased. Over Vijay's phone, Ronnie said to deceased that a meeting was being organized at Kharsingsa farmhouse and asked her to attend the meeting with Datang. Ronnie also told deceased that a carpenter had been hired for some repairing work. The money Vijay handed over to Datang was to be paid to the carpenter. That money was actually for Damrit as an advance for the work. At around 12 p.m., deceased and Datang went out of the residence for Kharsingsa in her Toyota Innova car bearing registration number so-and-so. At around the same time, Ronnie was going towards Nirjuli from Itanagar in his Creta car bearing registration number so-and-so. As per the plan of Datang and Damrit, Damrit was waiting at Bagetinali since 9 a.m. At around 12:27 p.m.,
Just let me give the name of the applicant in item. We
applicant
are in item 8 and 9.
7 and 8.
7 and 8, sir. So who is the accused in 7?
I'm the driver.
No, name.
Datang,
Datang Foyang.
Tata.
I'm the driver. Datang.
Datang.
DKNG. Accused number 1.
Datang. Tatang.
Datang,
Initially, an accident case was registered.
Khoyang.
Yes, KHOYA.
Okay, and this is in item 7.
Yes, PA number 21 of 26.
Okay, and
BA number
eight.
08 2020-26 for Tine Khoyang. Tine Khoyang.
Just a minute. Surname. This is in BA 8/26.
Yes.
BA 8.
Yes.
Okay, yes, now continue.
I'll start with
The money was
At around- At around 12:27 p.m. CCTV footage timing, deceased late Tichi Mina Lishi and Datang arrived at Bagetinali Nirjuli in the said car and parked the car opposite auto stand. And Datang got down of the car and called Damrit. After around 4 minutes, Damrit joined them. Damrit introduced himself as a carpenter to the deceased on being asked. The deceased was sitting in the front pillion seat and Damrit in the back behind the deceased. At around 12:32, they left Bagetinali for Kharsingsa. On the way to Kharsingsa near a garbage dumping point, Datang started singing an octave song as per the plan. On being signaled by Datang, Damrit took out an iron hammer and a pointed piece of iron rod from his backpack and attacked the deceased late Tichimina Lisi on the head and other parts of the body in the moving car. The deceased, after being assaulted, struggled and screamed heavily, and she abruptly kicking here and there during the struggle. She even opened the vehicle door to jump out, but she was pulled back by the accused duo, and then Damrit hit final blow on the head of the victim with iron hammer, and thereafter the victim was motionless. On passerby, so and so. Now, if I may take your lordship, this is the gist of the incident, your lordship. Now, if I may take your lordship to page numbers, page number
So the Datang was on the spot. He
on the spot.
participated.
Yes. Now, if I may take your lordship to page number 70, your lordship. This is
Okay, page
70, your lordship.
70.
70, your lordship.
Yes.
I'll just read the second paragraph, your lordship.
Mhm.
Further, on 29/10/2020, Roni again came to hotel room and paid advance cash of ₹2 lakh, which was received by
This was prior to the execution.
prior to the this was in the hotel was the execution. The plan for the execution being held, your lordship.
Okay.
Your lordship, if I may again read
Yes.
your lordship. Further, on 29/10/2020, Roni again came to hotel room and paid advance cash of ₹2 lakh, which was received by Tani Koeng, who is the applicant, Your Lordship, for the murder plot. In the hotel room, Ronnie showed them some sex video in his laptop, saying that the lady in the video is his wife, Meena, having sex with another man. But video in order to win the sympathy of other three co-accused person against late Tichi Meena Lisi. In the said hotel, accused Lisi Ronnie gave another 40,000 to Kapwang for his health checkup as he was unwell, but he did not go to hospital. And on 30/10/2020 morning, Kapwang and Tanye returned to Khonsa in Xylo vehicle of Changwang, his brother-in-law. Datang stayed back at Naharlagan in Mina's house. Later on 3/11/2020, Kapwang's brother-in-law Chamwang Mongwang brought one parcel from Itanagar on being given by Roni at Itanagar. There was 5 lakhs car inside. Then he talked to Roni. As per Roni's instruction, 3 lakhs was handed over to Tane Kipang as balance advance, and another 2 lakh was kept by Kipwang, Your Lordship. Your Lordship will see he is also involved in taking the cash which was promised as a
Who?
which
Data.
was Tanye Koyang.
Sorry,
Your Lordship.
Tane.
Yes, Your Lordship. Now, if I may take, Your Lordship, in the same point, if I may take, Your Lordship, from the down below, Your Lordship will count 2, 3, 6, 7, 8th paragraph, Your Lordship. From the down below, the 8th line,
Yes.
and it start with as accused Kipwang.
Okay.
Your Lordship will see,
Yes.
as accused, Kipwang and Tanye Khoyang already went back to Khonsa on 30/11/2020. During this period, Datang and Demrit had briefed him about the plan to murder the deceased. Before that, they were in constant touch with each other, over the phone. The CDR analysis revealed that Datang and Demrit started contacting each other over phone since 26/10/2020. That is when the plan to kill the deceased was told to Datang by Kipwang and Tanye. Meaning thereby, Datang was being told about the plan to kill by both Kepwang and Tanya, Your Lordship. Now, if I may take, Your Lordship, to page number 68, Your Lordship. I'm taking, Your Lordship, from the back of this story because since I have started with the murder part, Your Lordship, I'll just place out only his involvement where he was involved, Your Lordship, as per the charge sheet. Page number 68.
Okay.
Mhm. 68. उन्हें धीरे धीरे आगे से पीछे से ले जाएगा सर. Page number 68, Your Lordship.
Yes.
Down below, Your Lordship, the last paragraph. During the month of October 2020, Lisi Roni contacted one of his old well-acquainted friend, Shri Kapwang Latelawang, who used to be his classmate during early school days. Later, he used to look after the contract work at Khonsa. Roni asked him to arrange an assassin who would drive vehicle as well. Kapwang asks, Your Lordship will see 68A is the type copy, 61 direct. Tanya Koyang to arrange one such person. Your Lordship will see he is also involved in arranging the murder.
68A.
68A is the
Okay,
type
type
copy.
copy of this. Okay. Okay, then
It's
69. Okay.
68 and the rest
Arrange
is
one person.
Kapwang asks Tanya Koyang to arrange one person. Accordingly, Tanya Koyang introduced Your Lordship will see, introduce Datang Suyang to Kapuang Loang.
Just a minute. Hmm.
Accordingly, Tani Koyang introduced Datang Suyang. Datang Suyang is the other applicant
Yes.
to Kapang Loang. Kapang briefed Datang about the plan of killing the deceased and about the reward for the work. Datang agreed and thereafter gets tempted for money. On 27/10/2020, the trio Kapwang, Datang and Tani came to Itanagar. Roni paid rupees 25,000 to Kapwang for their journey expenses to come to Itanagar. They stayed at Hotel Supinsa, Itanagar, which was arranged by Lisi Roni. Room number so-and-so was booked in the name of Srip Kapwang Late Loang. Next day on 28/10/2020 morning at 7:50 hours, Lisi Roni arrived at hotel in his Creta car bearing number so-and-so in room number so-and-so in Supinsa Hotel, Itanagar. All persons, Kapwang, Datang, Tane, and Roni finalized the plan to murder his wife, late Techi Mina. Three other accused persons fully agreed to the criminal conspiracy hatched and convinced by main accused person fully agreed to the Lisi Roni to eliminate late Techi Mina Lisi and her unborn child. Further, Lisi Roni instructed them that it would look like an accident and assured them that nothing would happen. He would take care of the police case and would bail out driver Tatang within few days. Money for the work was finalized at rupees 10 lakhs, 5 lakhs in advance and 5 lakhs after the work. Now the promised amount was delivered through this applicant here in Tanya. Now if I may take your Lordship to page number 48. Your Lordship will see in this matter, the charge sheet was filed and subsequently two other supplementary charge sheets were filed, Your Lordship.
Hmm.
Page number 68, sorry, 48. Ek second, sir. Prior to that, if I'll just 48 paragraph, second, Your Lordship,
Hmm.
the second paragraph. During investigation, accused Tane Koyang was interrogated and recorded his statement where he stated that Kepwang Late told him to manage one person capable of driving car at Itanagar for his rich friend. Then he talked to Datang Suyang and took him to Kapoy Late Loang. Kapoy narrated whole story that his friend, whom later known to be Lisironi, wanted a person who can drive vehicle to kill his first wife. As per Kepwang, the reason for this was that the wife of his friend was disloyal to him and was impregnated by some other person. For this work, Kepwang told both that his friend will pay 10 lakhs. Datang accepted to it. Accordingly, they three came to Itanagar. The next paragraph, Your Lordship will see, Roni, Kapwang, Datang and Tane finalized the plan to murder Roni's wife at Hotel Supinsa. And Roni instructed them that it would look like an incident. The same narration, Your Lordship.
Hmm.
Even in page number 47, Your Lordship, there is a mention, Your Lordship, of the same narration. Since this is the first charge sheet, the the paragraph, Your Lordship,
Hmm.
it starts with during investigation. I'll just point out the line. 19th line, Your Lordship. Roni directed him to manage one person, Your Lordship.
Is Dhoni? Yes,
Directed
directed.
him to
Yes.
manage one person.
Hmm.
This is the narration of the same, Your Lordship. His name is also here. So accordingly, Your Lordship will see his involvement was from the very initial of when the plan was hatched. He had arranged the person who later on executed the work, Your Lordship. He was well aware of the plan. The advance money was given through him, Your Lordship. And later on, after the execution of the work, when the FIR was filed and the investigation carried on, Your Lordship, he was the one who has given shelter to the other accused, Your Lordship. Prima facie, there is a clear case of him being involved in this matter, Your Lordship. Now, I have certain authorities, Your Lordship, I would like to place.
Hmm.
I have certain authorities, Your Lordship, which I would like to place, Your Lordship.
Okay.
First, your lordship is well aware of this X versus State of Rajasthan, your lordship. Paragraph 16. It starts with paragraph 14, your lordship.
Yes.
If I may read, your lordship.
Yes.
Ordinarily, in serious offense like rape,
Okay.
murder, dacoity, etc., once the trial commences and the
Okay.
prosecution start exam 14 witnesses, the
Okay.
court the trial court or the high court should be loth in entertaining the bail
Yes.
application of the
Okay.
and 16 is the relevant paragraph, your lordship.
Mm.
Now, if I may take your lordship to another case, which is Kalyan Chandra Sarkar. It's a 14 and 16, your lordship, on the previous.
Now, you said that 32 evidence already, we have witnesses already
Wait,
examined.
Since I was from the very initial when this matters of bail came up in this court,
Hmm.
I had appeared on those matters. I'll just surprise.
Hmm.
On the first occasion when the first charge sheet was filed, your lordship, two of the accused were discharged, your lordship. For the reason why during that time the trial was delayed, I'm just trying to explain the court, your lordship. They had come before this court for challenging the discharge order, your lordship. Subsequently, the discharge order was quashed and the other accused
Okay.
was again taken to the custody, your lordship.
Okay.
Subsequently, on second occasion, again the same accused was discharged, your lordship. Then the complainant came to this honorable court challenging that the second discharge order, your lordship. Subsequently, this honorable court,
Second discharge order being to the same accused person.
same accused person,
Discharged after
Shumi
hearing
Kaya.
on the,
On two
at the
occasions.
time of consideration of charge.
First of consideration, yes, same court, your lordship. First, during CC, your lordship, she was discharged, that was challenged, and subsequently it was quashed. On the second occasion, after she was taken back to the custody and on the next occasion, she was again discharged, your lordship. The second discharge was also challenged for this court, your lordship. Now this court, after hearing all the parties, has quashed that discharge order. Subsequently, they approached the apex court, wherein apex court did not entertain their matter, and the investigation accordingly went by, your lordship. During that time, already many of the witnesses' examination was done, completed. But since after her discharge was quashed, the same witnesses had to be re-examined only for the purpose of her she being the accused, your lordship.
Okay.
And therefore, recalling of those witnesses took some further time, your lordship. Now, when the two accused who was granted bail had approached the apex court, your lordship, the apex court had not considered other ground except for the ground of incarceration, that only certain witnesses were examined and it will take a longer time to complete the trial, your lordship. And only on that ground he was granted bail, your lordship.
Okay, now,
Now-
my query is, since in the evidence of the 32, whether this person has been implicated, these two persons.
No.
I'll have because there is no eyewitnesses, your lordship. His involvement was through the CD, CCTV, and the registered CCTV of the hotel, CDR. These are because there was
Okay,
no
hotel
eyewitnesses.
person has already been examined,
Yes, ma'am.
the person from hotel.
Yes.
Not one of the person who maintains the registered. I have seen his statement, your lordship.
Mm.
But then he is not privy to the CCTV. He has handed over the CCTV to the IO at that point
Any
of
of
time.
the prosecution witnesses out of these 32 have been taken name of the accused persons, these two persons.
No, because all the prosecution witnesses are not directly known to each other, your lordship. Because
Okay.
this plan was secretly held by your lordship, as I've already pointed out.
Okay.
Lisironi had a good contact with Kipwang Late, your
Okay, then
lordship.
any of the accused person given 164 statement.
Yes, under the confessional statement,
Okay,
Yes.
so they have,
it's there that
Which-
the
okay.
driver,
Abang Sungai
the
kami.
driver.
how many have how many
Two,
of
two.
them? Two
The-
of them have given
Yes,
statement.
yes,
Okay, they
under 164.
narrated the same
Yes,
story.
yes,
Okay, so I think we can continue at 2.
yes, sir.
Going to take longer time.
No, your lordship, I'll just point out, your lordship, if your lordship take up the TCR, your lordship, I have marked on the side, your lordship will see two flag marks. The disclosure statement.
Okay.
Lordship will see on the side mark, I have flag marked it,
Okay.
the position of disclosure statement of,
Okay.
the first one is of Datang Suyang, lordship.
Okay.
Your lordship will find the name of the applicant herein, that's Tanya Koyang, as well as applicant in item number 7, your lordship.
Datang.
This Datang is the applicant in item number 7.
Okay.
They have not annexed it, so we don't have the copy of the.
Tempted. Yes.
Lordship, since I don't have a copy, I'm not able to.
Okay. Same thing.
Yes, your lordship will see in his disclosure statement. Due to this disclosure statement, the weapon used during the crime was also discovered, your lordship, as well as the SIM card and the mobile phone that was used, your lordship. Your lordship will see he has clearly named the co-accused, the applicant in item number 6, your lordship, and his involvement during the entire plan for the execution, your lordship. Next is the disclosure statement made this court, your lordship. Them
But
read-
he has taken name.
referred to as a mystery during the execution of the plan, your lordship.
Whether the Tane has also given? No.
No, no, no.
Demerit.
Yes. So your lordship will
He is
see
a
that
private driver.
the Datang is the driver who was appointed by Lisi Roni for execution of this murder. It was his plan to get him employed as his wife's, the deceased driver, your lordship.
Okay.
Now, this, the,
Datang.
yes, your lordship. Now, Tanye Koyang, which is the applicant in item number 8, he was the one who introduced Datang to Lisi Roni, as well as he was the one who has arranged the helped in the transaction of the money, your lordship, the advance payment, and subsequently
His role is,
introducing this person.
okay,
Your lordship will see,
he was a friend.
we are not aware if they were friends, but they were acquainted only because of this plan, your lordship. So he, on their request, he had arranged this Datang Suyang, your lordship. And he was well aware of the plan. He has narrated the entire, he along with
This Demerit arranged or
Tanye had arranged
Tani had arranged
arranged.
for?
Datang Suyang,
Okay.
the driver.
Datang.
Yes. In fact, if your lordship will again read the disclosure made by Datang Suyang, that he clearly states that the entire narration of the plan as well as the execution, that it should look like an accident,
Yes, yes.
was explained to him by both Kepuang and Tanye. So this Tanya was a middle person who has arranged the murderer, who has arranged the transportation of the money advance, who has also helped in shielding the accused after the execution of the crime, Your Lordship.
Tanya is the one who arranged money transaction.
Money transaction also, Your Lordship.
As well as
Arrangement of the murderer, Your Lordship. He has introduced the murderer who later on executed the plan, Your Lordship. And after the FIR was filed and when the investigation was initiated, Your Lordship, he also gave them shelter
Shelter.
at his field, house at his field, Your Lordship. My only submission is, Your Lordship, there is a absolute prima facie case against the accused.
Okay.
Now, I have two more authorities I have already given, Your Lordship. I'll just read out. One was X versus State of Rajasthan, which I have already.
Yes.
X versus Rajasthan, I have already brought, Your Lordship, notice about the same, Your Lordship.
Hmm.
Next is Kalyan Chandra Sarkar, Your Lordship. There is more particularly for in terms of incarceration, Your Lordship.
Which one?
Kalyan Chandra Sarkar, Your Lordship,
Oh, yes.
2004.
Okay.
Your Lordship will come to paragraph 13, page number 6. Down below is the page number, Your Lordship. Page number 6,
Yes.
paragraph 13.
Yes.
If I may read, Your Lordship.
Mm.
We have already noticed from the argument of the learned counsel for the appellant that the present accused has earlier made 7 applications for grant of bail, which were rejected by the High Court, and some such rejections have been affirmed by this court also. It has from 7th application for grant of bail was allowed by the High Court. The same was challenged before this court accepted the said challenge by allowing the appeal filed by the Union of India and another cancelled the bail granted by the High Court as per the order of this court made in criminal so and so. While cancelling the said bail, this court specifically held that the fact that the present accused was in custody for more than 1 year, and further fact that while rejecting an earlier application, the High Court has given liberty to renew the bail application in future where not ground envisaged under so and so. This court also in specific term held that condition laid down under section 437(11) is sine qua non for granting bail, even under section 439 of the court. In the impugn order, it is noticed that the High Court has given the period of incarceration already undergone by the accused and unlikelihood of trial concluding in the near future as ground sufficient to enlarge the accused on bail, in spite of the fact that the accused stands charged of offense punishable with life imprisonment or even death penalty. In such cases, in our opinion, the mere fact that the accused has undergone certain period of incarceration, that is 3 years in this case, by itself would not entitle the accused to being enlarged on bail, nor the fact that the trial is not likely to be concluded in near future, either by itself or coupled with period of incarceration would be sufficient for enlarging the appellant on bail when the gravity of the offense alleged is severe and there are allegations of tampering with the witnesses by the accused during the period he was on bail. Your Lordship, then come to paragraph 17, Your Lordship. We agree that a conclusive finding in regard to the point urged by both the parties is not expected of the court considering a bail application. Still, one should not forget, as observed by this court in the case of Puran versus Rambilas and another, giving reason is different from discussing merit of or demerit. At the stage of granting bail, a detailed examination of evidence and elaborate documentation of merit of the case has not to be undertaken. That did not mean that whilst granting bail, some reason for prima facie concluding while bail was being granted did not have to be indicated. We respectfully agree with the above dictum of this court. We also feel that such expression of prima facie reason for granting bail is a requirement of law in case where orders on bail applications are appealable. More so because of the fact that the appellant court has every right to know the basis for granting the bail. Therefore, we are not in agreement with argument addressed by the learned counsel for the accused that the High Court was not expected even to indicate a prima facie finding on all points urged before it while granting bail. More so in the background of the fact of this case, where on facts it is established that a large number of witnesses were examined after the respondent was enlarged on bail and turned hostile, and there are complaints made to the court as to the threats administered by respondent or his supporter to the witness in the case. In such circumstances, the court was duty-bound to apply its mind to allegation put forth by the investigation agency and ought to have given at least a prima facie finding in regard to these allegations because they go to the very root of the right of the accused to seek bail. The non-consideration of these vital facts as to the allegations of threat or inducement, so and so. The other ground, apart from the ground of incarceration, which appealed to the High Court to grant bail, was the fact that a large number of witnesses are yet to be examined, and there is no likelihood of the trial coming to an end in near future. As stated herein above, this ground or the facts of this case is also not sufficient either individually or coupled with period of incarceration to release the respondent on bail because of the serious allegation of tampering of the witnesses made against the respondent, Your Lordship. Now, the next is, Your Lordship, I have placed the judgment. It's of 2022, Your Lordship.
Yes, the-
It's Puran Mal,
New, what is new?
2022, Your Lordship. Puran Mal versus State of Haryana.
Yes.
Your Lordship will find at page number 3. I would rely on paragraph 9 and 10. Okay.
Yes.
It is a settled law that when the trial court has dismissed the bail application, and in present case it has been dismissed twice, what is expected from the High Court while taking a view different from that of the trial court, some cogent and valid reason ought to have been given for grant of bail. The nature of offense in the present case is very grave. The fact that this much, Your Lordship, and paragraph 10, though in order for grant or rejection of plea for bail is a discretionary remedy, several decisions of this court have been cited before us, which discuss the principle guiding this field of law. In Niranjan Singh and another versus Prabhakar Rajaram Khatore, it has been held that at that stage, court should be satisfied of prima facie case and detailed examination of the evidence is not necessary for considering this question. Imran Govind Upadhyay versus Sudarshan Singh and others, this court opined, and once the High Court refuses bail, to consider such plea and grant of bail subsequently must be supported by reasons. So even on previous occasions.
Okay, anything else?
Yes, the trial court, while considering the bail,
What your objection for the objection in granting bail is that
there is clear
the
prima
prima
facie
facie case.
case,
And,
Your Lordship.
when he was arrested, you said
13/11/2020.
13,
13/11/2020.
2020. Oh, that means 5 years.
Yes.
I guess. Now, my also the reason given that why
How
was
many PW exam? 32.
22.
22, Your Lordship.
22.
22.
22.
22,
It
because
was in the order in Supreme Court, Lordship.
Okay, after Supreme Court also some, okay, not yet.
And I'll just explain to that effect, Your Lordship.
The trial court rejected bail for how many times?
1 times.
Okay. Okay, yes.
The reason for that is because, like I have already explained, Your Lordship, that one of the accused was discharged on 2 occasions. They have approached this court also, who have quashed it. And now when she's on trial, because the trial already proceeded when she had approached this court, the complainant had approached this court for quashing of her discharge order, Your Lordship. Even during that time, the trial has already commenced and the examination of witnesses was in process, Your Lordship. Now, when the court,
Her means lady also involved.
lady, Your Lordship, the so-called mistress of the husband, Your Lordship.
Okay.
Now, what has happened is that once her discharge petition was quashed, she had approached the apex court, Your Lordship. Even then, the trial commenced and witnesses were examined. Now, after the apex court also did not entertain the quashing of her discharge order, Your Lordship, all the witnesses are again being
How
resummoned,
many witnesses were?
recall for examination only in terms of her part, Your Lordship. And therefore, there was delay, Your Lordship. The second part is that since the now I have seen, as per my observation in the record that has been placed before Your Lordship, is that after every 2 weeks, the matter is being listed, Your Lordship. And the trial as such has also taken the speed, Your Lordship.
After every two weeks.
Or 2 weeks.
Hmm.
The case is being listed, Your Lordship, and there is now the trial has also proceeded, Your Lordship.
Okay. So,
My humble
So-
submission, Lordship.
okay.
Just a second.
Hmm.
You'll have get your time. My learned friend, mine.
Yes. Anything else? You are for?
Victim.
Okay.
Basically, my lord, their prayer is on parity. But since one of the accused, Kapong Latte, he was granted bail by this honorable court by order dated 13/11/2025. So accordingly, applying the parity, he should be granted bail. So this same contention, it was raised before the learned trial court below. In the bail application 535 of 2025 that was rejected. And subsequently now they are before this honorable court. So regarding this parity, my lord, I have one judgment that I'd like to place. Parity is, my lord, not automatic, my lord. The role of each accused person has to be seen, my lord. This is Sagar versus State of UP and others. Kindly come to paragraph 10. Specifically in their application, my lord, paragraph 13 and 14 in their application, bail application, my lord, they have claimed the bail on the basis of parity, paragraph 13 and 14. So now this judgment, my lord, paragraph 10 may I read, my lord. The question that arises for consideration is whether, as done by the High Court in the impugned order, parity with the co-accused person can be the sole reason for granting bail. Bail has often been stated to be the rule and jail the exception. This cannot be emphasized enough. At the same time, this, however, does not mean that the relief of bail is to be granted without due regard to the circumstances involved in the alleged offense for which the accused person has been arrested. In this regard, it has to be noted that a court, while granting bail, has to consider a number of aspects. Judgments too many to count, delivered by this court, have delineated the relevant consideration to be kept in mind. A recent reiteration thereof was in so-and-so, that is reported in 2025 SEC Online 1690. The relevant extract thereof are as other. The principle which emerged as a result of the above discussion are as follows. An appeal against grant of bail cannot be considered to be on the same footing as an application for cancellation of bail. The court concerned must not venture into a threadbare analysis of evidence adduced by the prosecution. The merits of such evidence must not be adjudicated at the stage of bail. An order granting bail must be reflect application of mind and assessment of the relevant factors for grant of bail that have been elucidated by this court in so-and-so. Kindly come to para 11.
Yes.
It is clear from the perusal of the above factors that the High Court failed to consider all that was relevant. On parity, it is necessary to refer the case of so-and-so, reported in 2021 6 SEC 230. This court observed that while utilizing parity as a ground for bail, the same must be focused on the role of the accused and cannot be utilized solely because another accused person was granted bail in connection with the same offense, and neither can this ground be claimed as a matter of right. So, my lord, what I'm saying is, the role of that accused person whom this honorable court has granted bail and this applicant are completely different, my lord. Para 12, my lord. The High Court appears plainly to have erroneously granted bail to the accused respondent on the sole ground of parity, which it has misunderstood as a tool of direct application as opposed to parity, being focused on the role played by the accused and not the thread of the same offense being the only common factor between the accused persons. On this count alone, we can set aside the impugned judgment and order. However, we propose not to do so and proceed to delve further. So in an attempt to clarify the position of law for parity as a ground, we may refer to so many judgments, my lord, of various high courts, 13.1, 13.2, it was discussed. And thereafter, my lord, paragraph 16. In that view of the matter, the appeal is allowed and the judgment of so-and-so is set aside. The respondent accused so-and-so is directed to surrender before the concerned court. So basically, my lord, Honorable Supreme Court has said when to apply fairity. The role of each accused person has to be seen, my lord. It is not a matter of right, my lord. It cannot be direct, automatically applied, my lord.
Yes.
This is the case, my lord. And another, my lord, the bail granted to one of the co-accused by this honorable court is under challenge, my lord. We have filed a selfie. Before the Honorable Supreme Court, my lord. That is pending for consideration. Accused Kapong Leteloa.
Okay. Kapong was granted by this court.
This court, my lord.
Okay.
Those are on aspect of law, my lord. And factual aspect, learned PP has already apprised this honorable court. My lord, case is of very serious in nature, my lord. And this was the first of its kind in our state. Someone hiring a murderer from some other district in order to eliminate his own wife. So regarding prima facie material, my lord, it is there, my lord, more than prima facie. So trial, it was delayed only because of, as learned PP has apprised, my lord. Twice the same accused person, she was discharged, and it came up to this honorable court, and this honorable court interpreted twice, and that is the reason for delay of trial. So considering this material, my lord, since this is a serious case, my lord, bail may be rejected, and then trial is expedited, as learned PP has apprised this honorable court. So it is likelihood that within 3 to 4 months, at least, my lord, because in a single day, learned trial court is trying to examine at least 4 to 6 witnesses, my lord. So considering that aspect, my lord, this bail application of both the applicant may be rejected. And another one is, my lord, another bail application that Datang Suyang, my lord. He is the person who executed the plan, my lord. Pretending to be the driver, he was there with the victim deceased, monitoring, my lord, the entire movement, and then in connivance, in conspiracy with the main accused person, he, along with Damrit, both of them, they executed the murder, my lord. So therefore, my respectful submission, my lord, both the applicants do not deserve bail, my lord, at this stage. At the most, your lordship can direct a trial court to expedite the matter, my lord. That's all.
Yes. Okay. Hard. Mr.
Your Honor, as learned PP said before this honorable court that the trial is going on after 2 weeks. But this was only for a remand, for visit, not for trial.
Okay.
The last matter was fixed on 3/2020-26 for fresh recall witnesses, and fixed for another date, fixed for next May 11. This is the order. Here it is reflected. The PP have misled this honorable court lordship. And now my submission is that I have annexed in my para number 5 details of witnesses regarding whose are remaining are still pending in page number 5, para 5 or not? May I read, Lordship?
What is this?
This is the how many witnesses cross and who are remaining are wait to cross like this.
Hmm?
How many witnesses already crossed and now remaining remaining
Okay.
disclosure statements, Caesar witnesses, all are
Okay.
pending.
Okay, no.
This is the statement as mentioned in para
Not
number
required.
5, page 5 to 7.
Hmm.
May I read, Lordship?
Not required.
Yes. Then one witnesses, namely Changlang Muang, in page number 180, 1182, 120. Can you look at him? Yes, annex of 5, 5E,
180,
PW 5, page number 118.
118.
Yes. 118
Okay, what is that?
or not? Deposition and cross lot. Out of 5 accused person, I can identify Lisironi, Kapang Lite Lawang, Tine Koyang, and Datang Siang. I cannot recognize the other person. On
Okay, who is this?
27,
Who is this?
this is the driver, Jailo driver, who, as per allegation and as per search, who have brought the money to Kuncha to deliver Tine Koyang.
Okay.
This is the statement, deposition statement. Out of 5 accused person, I can identify Lisironi, Kapang Lite Lawang, Tine Koyang, and Datang Siang. I cannot recognize the other person. On 27/10/2020, Kapang Lite Lawang and Tine Koyang came to Itanagor in Jailo passenger vehicle of other person. On 28 October 2020, I went to Hotel Supinsa to meet my brother-in-law Kapang Lite Lawang. That means the PWS is the brother-in-law accused Kapang Lite Lawang. There I saw Tine Koyang and Datang Suyang inside the hotel room. After some time, Lisironi and Akin came to hotel room to meet Kapang Lite Lawang. Here the Akin is the brother-in-law accused Lisironi. This is also PW, witness lordship. On 29/10/2020, I went to Hotel Supinsa to meet my brother-in-law Kapang Lite Lawang, and that time Tine Koyang also present in the hotel room. They told me that they would leave next day for Kuncha. On 30/10/2020,
What do you want to
Kapang
show
Lite
from
Lawang
What do you want to show from here?
want to show that the allegation is alleged by the search it or the investigating officers that 5 lakhs rupees is carried by this PW, who is his planned mother for pre-planned mother for 10 lakhs, 10 lakhs advance, 5 lakhs advance, and 5 lakhs after the work. This is the person who brought the amount. But in fact, in cost examination, it is reflect that the amount, the parcel was not in rupees. The parcel included in templates and poster of energy holdings, as per course examination of this witness, lordship, PW5, Sanglang Momang.
Okay.
May I read, lordship?
Read the relevant portion only. It's a
Ah.
long one.
Okay.
Can't read. No.
The course examination. Page number 119, lordship. I used to leave from Itanagar to Khonsa in my Jailo vehicle at about 5:30 a.m. along with my passengers. Mr. Akin is the brother of Pechimina. On 28/10/2020, I went to Hotel Chopinsa, Lisironi, Kapang Lite Lawang, Tanye Khoyang, and Akin were talking about their childhood and discussing about energy drinks project. This is Akin, who is the brother-in-law accused Lisironi, Akin. We're talking about their childhood and discussing about energy drinks projects. On 29/10/2020, when I went to Hotel Chupinsa, I forget whether Lisironi was in the hotel or not. On 28/10/2020, when Lisironi arrived at hotel, he brought 3 keypad mobile handset. But I cannot say if there was any SIM or not. These 3 keypad mobiles were handed over to driver Datang Soyang. Datang Soyang used one mobile handset and another one handed over to Ninang. And Datang Soyang was keep in their local language, speak in their local language Nokte. and the third was kept at the office of as instructed by Lisironi. During the time of handing over the handset by Datang Soyang to Ninang, Lisironi, Kapang Lawang, and Tiniek Hoyang were discussing about energy drinks. It is a fact that when I went to Hotel Supencha, I did not hear the accused person discussing or planning about killing Techimina. It is also a fact that on both the dates of my visiting Hotel Supencha, I did not see the accused person either giving or taking money to anyone. On 1/11/2020, in the evening hours, Lisironi had called me opposite to ICICI Bank Itanagar, and on 2/11/2020, by taking the parcel given by Lisironi, I went back to Khuncha, and at about 4:30 p.m., I reached Khuncha, and on the same day, that means 2/11/2000 evening, I gave the parcel to Kapanglite Lawang. First, I did not contain the parcel. However, later on, when Kapanglite Lawang opened the parcel and showed me, I saw that there were some pamphlets and poster of health energy drinks inside the parcel. I do not remember on if 3/11/2020 Lisironi called me or not over phone. Now, the allegation against
Okay.
Now, allegation against the accused person that he have received amount of rupees 2 lakhs at Hotel Chupincha on dated 28/10/2020, and another 3 lakhs was received through this person, Kapanglite Lawang. But in charge sheet, in the Chija memo as annexed by the investigating agency in the search sheet, right? Page number, Lordship, 179. This is 179 page number.
What is that?
This is the Caesar memo. The amount which was recovered from accused Tiniek Hoyang, this applicant, Lordship. Type copy page 180, Lordship. Case amount of Caesar list, Bandardia case number 22/20 under section 302, 120B, 301, 279, 304 dated 13/11/2020 around 1:40 hours, Lordship. Case amount to rupees 500 into 8, rupees 4,000. This is in page number 180, type copy.
Okay.
Allegation is 5 lakhs, but police have seized only 4,000 rupees from the accused person.
So how can we expect when the money was stated to be handed over to him?
Same day, Lordship. 2 of November 2020, and police have seized on 13/11/2020. 80.
Money was given on?
Money was given on, one is on 28 October 2020.
Okay,
And another is sent on 2/11/2020.
okay.
Then the police has seized
Then the 400 is more,
4,000.
4,000,
Allegation is the 5 lakhs rupees.
5 lakhs.
Yes.
Yes, what do you want to show here then?
That means the police have, though mentioned in search sheet, but police have seized only 4,000 rupees from the accused. That means baseless allegation.
Police says that
As per search,
5 lakhs was seized from
Yes.
him.
Oh, yes, as per search sheet.
5 lakhs was seized.
Yes.
Where?
No, 5 lakhs was seized now. 5 lakhs was in the bank, in the bag of Tiniek Hoyang, Lordship.
Seized from?
No,
Tiniek Hoyang?
seized only 4,000.
No. What the police says?
Yes.
Seized how much amount?
Seized only 4,000 rupees.
How much the police says?
Police says 5 lakhs rupees.
Seized.
No, seized, not seized.
What are you saying, Council?
Lordship, Lordship.
5 lakhs was seized or given?
Given.
Given, how do you expect that same amount will be seized after so many days? Yes, anything else?
Our Lordship, yes. The main accused, Lisironi have granted bail by Honorable Supreme Court, and accused Tayasumi have already granted bail. Kapanglite Layang has already granted bail. The learned victim advocate said before this court that Kapanglite Layang bail application was challenging before Supreme Court. Yes, in the ground that they have in the Kapanglite Layang bail order, they have not party made in this court, before this honorable court, not made in party. But this is the different things. We are in separate things, Lordship. The petitioner also behind the bar since so and so, 13/11/2020, and more than five years over, and still pending the trial. It will take time, Your
We
Lordship.
have already.
Though my learned people stated before this court that after 2 weeks the matter is listing, but this is for only for remand, not for trial. Trial is for 2-3 months, taking 2-3 months for any evidence, Lordship.
Okay.
That's my call. From my humble submission, this honorable court may granted bail to the accused person in any condition as required to the court, Lordship.
Okay.
Obliged.
Mr.
I get something and for the same,
Two applications.
Two application.
and item number 7, Your Honor.
Okay, you are in item number 7.
Yes, it's,
Okay.
this is the BA number 21 of 2026 in connection to the same case. Your Honor. The bailer here is the younger brother, and this is my second bail application. Earlier, my BA number 51525 was rejected by the Learned Sessions Court by order dated 5/1/2026, which is given in my petition page number 21. Earlier in this case, it has been repeatedly again and again stated, the two main accused persons were on bail, one being the main accused person, Lesi Roni, and the second being the Kabong Lateloa. Here, in both the cases, it was seen that grounds being prolonged detention and long incarceration.
You are for
I am for the Datang Soyang.
Datang.
My ground is that principle of parity. I've come before this, Your Honor.
Okay.
Yes.
Parity and
Yes, Your Honor. Your Lordship.
Yes.
They have been repeatedly, the PP as well as the learned senior have been.
when he was arrested on the same
I
day.
was, no, I was arrested from the ground, 6/11/20. I'm the driver. And today it's more than 5 years, 4 months. Now the PP and the learned senior counsel for the victim has been repeatedly stating that I am not on the same footing. How am I not on the same footing? What are the grounds that they're stating that I'm not on the same footing? Whereas the 161 statements, 164s that they have been repeatedly reading out, nowhere my name is mentioned. They keep on mentioning Lesi Roni, Kabang Latelawang, then Thane Koyang, and Damrit. Whereas I'm not denying that I'm the driver here. I am the driver. The accident happened. I was taken from, I was arrested from the spot. The first FIR was of for rash negligence.
You were engaged as driver for the deceased
Yes,
by
by both of them.
Tane.
No, not Tane. Tane is not the husband.
engaged by Ronnie.
I am simply the driver here, Your Honor.
Okay, you were engaged by Ronnie.
Yes, Ronnie
Okay.
and the white ladies is
Okay, since when?
since 4-5 months before the incident. Or I think how many months? I'm the driver. Not 1 month. More than 4-5 months, I think.
Okay,
Today, the ground that I'm taking is the principle of parity.
yes, noted.
Yes, Your Honor.
Anything else? Any other ground?
And the other thing that they've been stating is that disclosure statement. There is a disclosure statement that I've given, and it was given on dated 12/11/20. And that disclosure, every disclosure has have to lead to recovery of certain things. The CCTV was recovered, not the weapon of offense. CCTV was recovered, giving as to my role from where I have gone, what I have done. I've given everything. So this is all the more grounded. I have cooperated, and there is nothing else that I have to say. And there is the citations that they have put forward is that the earlier citation was that of hampering, tempering. Here in this case, whatever I know, I've already deposed before the court, before the police. The disclosure statement has given. There's nothing else. So now we are left with only matter of trial. Now, whether I'm already been convicted or I should be given a fair opportunity. Now the trial is going on for the past 5.5 years, and it is still lagging behind. 43 witnesses, out of that only 22 has been given, examined, and 6 witnesses have been recalled. And my learned PP has mistakenly stated that it has been put up after 15 days. That is the remand through VC that is done for 14 days JC remand. Earlier, this 3/3/2026, it was put up for witnesses. Then now it is next fixed for 11/15. My prayer before this honorable court is that this is a fit case for principle of parity. It may be considered since taking into ground that
Next date, when you said fixed for?
11, it must be already
11 of?
there. 11 May.
Okay,
It must be reflected in the orders in the TCR.
okay, okay,
The last date was 3/3/2020.
okay.
With due reservation, my lord, just only one document.
What-
Last
what?
order, last order. my lord.
Hmm.
3/3.
Kindly, my lord, see the learned trial court below, the endeavor that is being made by the learned trial court below. This is the last order, my lord. Kindly see paragraph 5,
Hmm.
the relevant one. Fixed on 11/5/2026 for appearance production of the accused persons and for examination, cross-examination of PWs, my lord.
Yes, 11.
Lishi Leji 1, Lishi Yamin 2, Taba Nanu 3, Biswajit Das on 11/5/2026, my lord. Dates are blocked. On 12/5/2026 for PWs, namely Lisi Kojum, Lisi Yapu, Mari Karbak, and Marto Ingo. Second day block, my lord, date blocked. Third date, my lord, 13 May. For PWs, namely Techi Yasa, Navam Takek, Sanju Roy, and Tadar Thomas on 14/5/2026. Tanu Raju, Lisi Joni, Navam Torum, Techi Kak, Prabhat Mahato, Dr. D. Panya, Tanya Soni, and Ritu Tawe. And on 15/5/2026 for examination of PWs, namely Inspector A.K. Pandey, Inspector S.S. Jha,
Okay,
S.I. These are the endeavor, my lord. The
okay, so almost.
dates are blocked. Yes, my lord.
Hmm.
So this 11, 12, 13, 14, 15,
Conti-
almost more than
continue.
20.
Okay. Hmm. Okay.
May I humble summons your lordship? My humble summons your lordship.
Hmm.
Yes, my victim advocate stated before this honorable court that on 3/3/2025, the trial court have fixed 11/5/2025 to 15/5/2025 for cross-examination and evidence days. But the square thing that is earlier before this honorable before by this trial court before this day also fixed this type of date, but none of witnesses appear before the court in due time as to why the delay is going on. Yes, trial court had issued summon to the accused person, witnesses person, but the witnesses not appear before the court in due time. That's why delay is going on, lordship. TCI record, it may be reflected in TCI also.
Okay. Hard. Mr. Huh? No, SB the Line Council for the petitioner in BA 21, 21, 26, and Mr. G. Phukan, Line Council for the petitioner in BA 8, 2026. Also had Mr. Ms. Chidi, Line additional PP for the state, and Mr. K. Tama for the victim
Victim informant. my lord.
informant side, assisting the land additional PP staff. Okay. So hearing concluded, judgment will reserve only. Okay.
Highly obliged.
Hmm. Huh? Hmm. Okay. Yes, next.
Item number 9.
None appears on behalf of the parties on floor. List this matter. What is this matter? This is criminal petition. whereas Ms. Jenny Lan, additional PP, is present in absent of the counsel for the petitioner. This then adjourn, list is matter after a week. Okay.
Matter number 10,
Okay, Mr.
And a permanent resident, the respondent number 3 and the present posting place.
In view of the office note dated 25/2/2026, Mr. Home Modi, Land Council for the petitioner, request for allowing him to take fresh steps upon the respondent number 3 in his present address,
Present posting place.
present posting place. The prayer allowed, is allowed steps within 3 days.
One.
Or within a week from today. List is matter after 3 weeks.
My lord,
They are from,
my lord,
where is his present posting place?
on, period filing of this petitions, he was
No. Okay, now after 3 weeks or 4 weeks?
after 3.
Okay, after 3 weeks. Okay.
My lord, this was report of the police was called for.
Yeah.
Your Lordship, this matter was already charge sheeted on 30/4/2013, while charge sheet number 47 of
Okay,
2013.
so now trial court record need to be called for.
Yes, Your Lordship.
Okay, no, okay, then submit that, Miss Jeannie Lan, additional PP, submits that the case has already been charge sheeted. Which court?
I'm not sure because when the charge sheet was filed, Your Lordship, there was only court.
CGM court for past step only.
Pasigat. Okay, Pasigat. Okay. In view of the above, call for the trial court record. A scan copy of the trial court record. Okay.
Your Lordship may kindly if write down the charge sheet number, Your Lordship. Charge sheet number is 47 of 2013.
Call for the trial court record being charge sheet number
47 of 2013,
47 and 2 of 2013,
dated 30/4/2013.
30/4/2013 in FI, which PS case?
Pasigat,
Case number 12 of 2013.
In Pasigat PS case number 12 of 2013 under section 332 of IPC. Okay.
matter number 11,
Non appears. On call. List is after review. Okay.
matter number 12,
Yes.
Following this application for crossing of the FIR, my lord. The CD was earlier called for and my lord, it was received. The action was given to retain it, my lord. No, it's a completely my lord, vexatious, my lord, and frivolous FIR.
Is it contested or
Yes, my lord, all appeared, my lord.
okay?
Your Lordship, I'm appearing on behalf of Mr. S. Koyang, respondent number.
Respondent number 2.
Yes, Lordship. He's out of station and please may listed after this matter.
Just a minute. Okay, you have not yet filed objection. You want to file, are you filing objection or not?
Yes, Lordship.
They already granted my lord 3 weeks time, my lord, by the order at 19-1.
19-1, yes. So what is the offense here? 318.
If your lordship looks into my lord the FIR,
Okay,
I'll just take your lordship to few my lord lines, my lord. Is at page 36, lordship may come to page 38, that is type copy. I am Amit Poddar.
oh, you are Amit for that.
Page 38.
Yes, 36.
Subject complaint against Amit Poddar. Now present petitioner is the Amit Poddar,
Okay,
proprietor of Poddar's hardware store of cheating, thereby dishonestly inducing payment of rupees 3 lakhs. With due respect, I'd like to
No.
inform that say Amit Poddar, proprietor of Poddar hardware store, is running a hardware shop at Ganeshguri near police station. Now pausing for a moment here, if your lordship comes to page 13, 1-3.
Hmm.
This is your lordship will find Subhash Chandra Poddar, son of so-and-so, the name of so-and-so. Messrs Poddar hardware store. My lord, Subhash Chandra Poddar is the owner of my lord Poddar hardware store.
Okay, you are proprietor.
Subhash Chandra Poddar is the my lord proprietor,
Okay, not you.
not the one. I am Amit Poddar, my lord.
Okay,
Then your lordship will go little more, my lord.
but you are protected by interim order.
My lord, no coercive action be taken, but the
Okay.
proceeding is going on, my lord, is an unnecessary harassment. And the second aspect, your lordship will again,
It is at what stage?
but investigation is going.
Investigation, okay.
Investigation, my lord.
Investigation. Okay. So your contention is that it is not you.
Yes, not only that, your lordship may come to second paragraph again, my lord. So Amit Poddar told me that he has iron rod, cement and other building materials for sale in his hardware shop and sought for an advance payment and assured to supply the aforesaid building material thereof. I have paid a sum of rupees 3 lakhs only to Sri Amit Poddar by depositing in his account number so-and-so through RTGS by check number so-and-so dated so-and-so.
So this account number belongs to you.
Page 15, your lordship may come, my lord, page 15 for a moment, my lord.
Hmm.
This is the first line, your lordship will find Poddar's hardware store.
Okay.
It is not Amit Poddar. And the entry is, my lord, 1412. The first entry, your lordship will see, my lord, that is the amount.
Okay.
That is the amount. And the check, your lordship will find at page 22. In the complaint further, my lord, it is contended that
Okay. In the name of the new, in name of the hardware.
in the name of the
Okay,
hardware.
not in your name.
Not in my name, not in
Hmm.
my account, it is the Poddar's.
Okay, but then you are working in that hardware shop, hardware.
Well, I just sometimes, because that is my uncle's
Okay,
shop, sometimes
okay.
I see.
Anyway, so since the Land Council is out of station, we'll give some more time. Mr.
M. Doliang.
Land Council, submitted the conducting council, Mr. Escoya, is out of station. Therefore, pray for some more time. How much time you are praying for?
Your lordship, 2 weeks will be.
Further 2 weeks time to file objection.
Lordship, in the meantime, we are directed to produce the updated case study, Lordship.
Okay. Mr.
Okay. Okay.
PJ Sakya, Land Senior Council, assisted by? Okay. You have an objection to the, no, the time can be given, allowed?
Since
Okay,
it is out of
okay,
station,
has no
I
objection.
be, my lord, pressure.
Accordingly, the prayer is allowed.
But only my prayer would be, my lord, to give it as a last chance and for observation
Okay,
for
but then
disposal of the matter.
ensure that on within 2 weeks you file. Okay, ensure, huh?
Lordship will
Hmm.
fix the
Please.
matter on 20th of April,
Okay.
my lord.
Okay, Miss
Was in between vacation for Bihu.
El Hagel and additional PP is also present, staff, on the request of the parties. List this matter, on
20th April, my lord. 20.
28 April.
Lordship, Miyoko festival is going on.
April, this is April.
Yes, Lordship. Miyoko
You want this matter to be fixed on March?
No.
Festival is on March only. See,
So
he's
after
praying for 20 April, not March. It's after 1 month.
April.
20 April, On which date the land additional PP shall produce the updated case diary. A scan copy of the case diary. Okay.
And my lord, further observation that matter would be disposed of,
The-
but we
Ah.
the matter without further matter adjournment.
Just a minute, because let them file objection first. The interim order passed earlier shall continue till the next date of this day. Okay.
Much of that.
And that order is already until further order.
Until further order,
Already.
then no need to no need to repeat it. Okay. If it is,
Only an observation for disposal of the matter on that day.
okay. On which date the
On the.
an endeavor shall be made to dispose of the matter. Okay.
Lordship.
Item number 13,
This is again, my lord, question, my lord, this is entirely a civil dispute. It's regarding, my lord, sale
Just a
and.
minute, till the returnable. No, don't see. Not this way.
Yes, lord.
Okay, till further order. Yes.
Lordship, in this matter, we have not received the CD, though we have given a reminder, Your Lordship. If Your Lordship fix this matter.
CD
on some
not yet
other date,
received?
Yes.
This is also still under investigation.
Yes, my lord, this is also, my lord, under investigation.
Okay, so this is joint petition or
No, my lord, one
okay,
person.
contested?
Is a separate, my lord, separate.
Okay. So whether the private respondent appeared?
On
Appeared.
28/1, his presence,
It's recorded.
it has been recorded on last order, Your Lord.
Wakalatnama not yet filed.
He will be filing Galatnama.
Mhm.
He may be filing, my lord. Mr. M. Como, learned
Mhm.
counsel, has entered appearance on behalf of respondent number 2 and submits that he will be filing his Ukalatnama during the course of the day. And my instruction that Ukalatnama has already filed.
Oh, already filed.
Name show position.
His name is also reflected in
Okay,
Wakalatnama.
okay. Oh, it's there. Item 13. Yes.
Name is also
They are not appearing.
not appeared.
Okay. Okay, Mr. P.J. Sakya. Land Senior Council assisted by. He is present. Miss Jenny Lanet, additional PP for the state. Some states, although the scanned copy of the case diary was called for, she has not yet received the case diary and therefore pray for some time. Although the name of the counsel for the respondent number 2 has been reflected in the course list, no one appears on behalf of the respondent. Okay, start now. In view of the above, let this matter. In view of the above, and as prayed for by the learned additional people, let this matter be listed on same day.
Same day.
Okay, on 20
Until
April.
when,
On which date the learned
make sure that
additional
this is
PP
clear.
shall produce the updated case diary. 20. Okay, you on that day you produce updated case diary,
Yes, Your Lord.
scan copy. Okay. Okay.
further objection without fail, my lord. It's a 2025 case CD has not.
Yes, without fail. Okay.
Different.
Interim order passed earlier.
The interim order passed. There is interim. Here also no coercive.
No coercive.
The interim order passed earlier shall continue till the next date of listing. Okay.
Item number 14.
And Mr. Lordship, decision 528 BNFS application for challenging the order, impugn order dated 23rd 6 2025 passed by the Land Special Judge NDPS UP Papumpare
Just
in NDPS case number 31 of the 2020.
this is
Yes, Lordship. Page number 15.
criminal petition.
Page number 15. The impugn order, Lordship.
Just a minute. Huh?
And XRD. May I read, Lordship?
Just a minute. Huh? So page 15 is
Is the impugn order, Lordship?
impugn order.
Yes, Lordship. To the present case is fixed for production of
Just a
accused.
minute, huh?
Accused person, namely Asarullah, is
Just a
produced
minute,
by
huh?
payload.
Yes. This is impugn order. This is criminal
Yes, sir.
petition.
Criminal petition, Lordship.
Okay. Yes.
The impugn order dated Lordship 23rd 6 2025 and XRD page 15.
Yes.
Today present case is fixed for production of accused person, namely Asarullah, is produced by Belor City Pranab Soikia. Learned Council City and Bangkang has appeared for the accused person. State is represented by Learned PP Ms. B. Yari. Learned Council Mr. S. V. Darang has appeared for Belor. It is submitted by the Learned Council appearing for the accused that the accused is not cooperating with him and even the family members also avoid him. I have heard the accused person who has stated that he could not appear before the court during the trial as he was at Kerala for some work. It is observed that from records of case that while granting bail to the accused person by order dated 4/2/2020, passed in BA number 15 of the 2020, conditions was imposed upon the accused person, including that the accused shall not leave the state of Assam and Arunachal without prior information. It is observed that the accused while going to Kerala has not taken any permission for giving information regarding his leaving state of Assam and Arunachal Pradesh. Even the accused person has remained absent during trial of the case, causing unnecessary delay in trial. As such, the bail granted to the accused person is cancelled on violation of bail condition by the accused person, Lordship. This is the impugn order. And the seen Miss case number 168 2000 filed by under section 489 of BNSS, paying for discharge of the bailor. It is submitted by the bailor and his counsel that.
Which one you are reading now?
Yes, Lordship.
Which one you are reading now?
I am reading the impugn order dated 23rd 2025,
Yes.
page 16.
Okay, 16. Para?
Para 4, Lordship.
Okay,
See,
okay.
Miss case number so-and-so, file under
Okay,
section
okay.
so-and-so,
Hmm.
praying for discharge of the bailor. It is submitted by the bailor and his counsels that on 2 occasions notice to the bailor was issued and presently the bailor is posted at Gwalpara and he is not in a position to stand as surety on behalf of the accused. It is prayed that the bailor may be discharged. After hearing learned counsel and after bailor, the prayer is allowed. Bailor Sri Pranab Soikia is discharged. Miss case number so to dispose. The accused person Nelly Sri Asarullah is taken into custody of the court. The accused person is remanded into custody and he be medical examined before lodging at the judicial custody. It is observed that the present cases for test of examination of PWs and for witnesses are already examined. This is the impugn order, Lordship. The bail is granted by the Session Court in Bhai order dated 4/2/2020. I have annexed the same in page number, Lordship. 12. 1-2. Annexure B. The bail application is filed under so. This is the not relevant portion is the page number 13. Point number 4, Roman point 4. He shall not leave the state of Assam.
Page 13.
Page 13, Roman 4, para.
Mhm.
He shall not leave the state of Assam and Arunachal without prior information, intimation to the IO. This condition is violated by the accused person.
Hmm. So
And
then-
that's why the line trial court had cancelled his bail. One.
Okay, then,
And without hearing and without issue notice and without issued any notice,
No
Only
notice
if-
was issued.
Lordship?
No notice was issued.
Yes, Lordship.
Yes.
Did she have come?
Lordship, here, Lordship, he is, Lordship, violating the bail condition,
No,
Lordship.
maybe, but then notice should have been issued.
Lordship, because Lordship, he already knows that, the
What?
next date is, Lordship,
Even then, you need to, you need to be issued notice for before cancellation of the bail.
but at that time, Lordship,
Cannot just cancel the bail in that way. Whether any bailable or not non-bailable warrant of arrest was issued against him, it's not that he has been taken into custody in execution of the non-bailable warrant of arrest issued against him. It's a cancellation, but then before cancellation, you need to issue notice only.
It is done by pronounced citation, I will quote types in DA number of or equivalent petition number 246, 2025. Order dated.
Have you seen the record? Where, have you seen the record?
not yet, Lordship.
What we'll do is you just go through the records. If there is any notice was issued or warrant of arrest was issued, and then if he was arrested in execution of the NBWA issued against the accused, just go through the record and then submit.
Yes.
Okay.
Lordship, just say,
Tomorrow,
for time being, Lordship, so last
time being-
item, Lordship,
uh,
otherwise,
If it can be done
yes, Lordship.
sooner the better.
Para 4, Lordship. In criminal petition number 246, 2020-25, I have perused the order dated 20 past by the learned special and EPF from the order also, especially para 2, no any notice of hearing of accused is legal. Thus, in the instant case, the cancellation of bail of the accused was not as per proper procedure and by complying with the principle of natural justice which
Okay.
required.
Hmm. This is in which case? Monu Sharma. Okay. Okay. Next.
Apply.
After some.
Item number 14 and 15.
This is item.
14, Lordship, sorry. 15 and 16, item number.
No? This, I has been, my lord, filed for vacating the order dated 24/11/25. My lord, that's page 43.
Lord, before my friend starts, my lord, I have to take my lord to the my lord's order only, dated my lord 21st of January 2026. My lord has that order? 21st of January 2026, the order of this honorable court only.
What? Order
The
of
order.
this-
Yes, my lord.
Okay. Page,
21st of
page-
January. No, my lord, from the record itself, my lord's order, or out of the order sheets, 21st
in a
of
criminal
January.
petition.
In this case, in this very case only, my lord.
In which case?
In the main case,
In
in the main
IA?
case, my lord. In the main case, my lord.
Main case.
Yes, my lord.
21st.
21st of January, my lord. Somebody
20?
from 21st of January 2026.
21st January.
Yes, my lord.
Okay. What is this? Yeah.
Learned counsel so makes a mention,
Yes.
which was their office, the office of my learned friend, senior friend only. They made a mention before this honorable court saying that they need time to file objection affidavit. They took the time to file objection affidavit, and which has not yet been filed. And without filing objection affidavit, they come up with the application, which is before my lord, while in the separate case, which was just before my lord. But how they can argue the application seeking vacation of the stay which this honorable court has granted earlier on 24th of 11 without letting their stand know to us, my lord? They were to file the reply to our petition first. And after that, whatever they had to say, they could say. Our petition raises multiple substantial question of law. You're not coming around them, you're not answering them, and you're coming up with the application. And application is also about something which is inconsequential. So I think my learned friend should file the reply first, and then if he's agreed of the order of this honorable court, then certainly that can be debated and discussed.
Lord, I am thankful for giving the suggestion by my friend, but this application is for vacation of the interim order, not of the hearing of the petition where the affidavit is to be filed. The
No,
time
can
was
this
thought
application,
for
can this
hearing, but
application be
now here
heard?
application. So therefore, I am on the point of, my lord, vacation of the interim order, which was granted only till the next date of hearing. Now Lordship is exercising, my lord, power under article, my lord, this section, my lord, 482. Now, my lord, this
528.
section 528, my lord. It's a very limited, my lord. Nothing can be, my lord, said outside the records. Record has been called for. Record is before your lordship. Now your lordship will, my lord, see whether this order need to be continued or not. If it is not to be continued, lordship will discontinue the order and hear the petition on merit.
Just a minute. The stay was granted to what? The
Operation
Till
of
the
the
next
impugned
date
order
of
was stayed. Till the next date of hearing, the operation was stayed.
what was the
Because-
direction in impugned order?
Impugned order direction was that, can we have the
Well, it's a
order
basically,
itself?
basically.
No.
It's my-
This is a
let
relevant
me
question.
submit it. Let me fact.
One by one, please.
Yes.
Right.
My lord,
Yes.
basically, it is a, my lord, scam, my lord, in a way, my lord. I am, my lord, NHIDCL, my lord, a government, my lord, company, Government of India company, my lord. We have floated a tender, and, my lord, the successful bidder, my lord, was granted with LOA. Now, pursuant to the LOA, I'll take your lordship to the, my lord, particular page also, my lord. Page 66 is the LOA. This is, my lord, Kamak Engineering Private Limited. And in paragraph 3, your lordship, page 66.
What is this?
Page 66 of the, my lord, this main petition, my lord. I'll rely everything, my lord, from that petition only, my lord. No new document has been enacted in the IA. Paragraph 3, your lordship will see, my lord. The LOA has been issued to Kamak Engineering Limited. Paragraph 3. You are also requested to furnish performance security for an amount of rupees 8,18,31,000 and additional performance security for an amount rupees 8,18,031. 8,18,31,000 as per clause so and so, RFP so and so. Now, 4, my lord, bank guarantee has been, my lord, submitted. 2 we have already enforced. So far as this one is concerned, my lord, we'll find at page 80. The bank has given the guarantee on behalf of, my lord, Kamas Engineering Limited. This is one. And another is for the page 95. And what are the conditions you also will find, my lord, page 88. That is the basic, my lord, DG conditions. Now, bank is giving guarantee on behalf of, my lord, Kamak Engineering Limited. And line number 30, your lordship will see, my lord. Now, therefore, the bank hereby unconditionally and irrevocably.
Where are you reading?
At page 88.
Okay.
That is the, my lord, BG conditions. the bank has given me.
Line number?
Line number 13.
Hmm.
Now therefore, the bank hereby unconditionally and irrevocably guarantee and affirms as follows. The bank hereby unconditionally and irrevocably guarantee the due and faithful performance of the contractor obligation during the liability period and under in accordance with contract and agree and undertake to pay to the authority upon the mere first written demand and without any demur, reservation, recourse, contest or protest or without any reference to the contractor such sum or sum of to an agreement to an aggregate sum of the guarantee amount.
So since you have filed, what we'll
So
do,
this is a
just a minute,
it is a-
This is, we will issue notice then here in the IA. Notice
they-
issued,
but-
not yet issued.
They have already,
Let, huh?
copy has already been
Copy
served.
served.
Copy served.
So you want to file any objection?
But
Are you filing any
yes,
objection?
I would like to file the objection, my lord, and it's in the meanwhile, my lord,
Okay.
they also have to file the objection.
Notice not yet issued. It appears,
Lord,
copy
yes.
served. It was a leftover, it
Copy
was
served.
not taken up also.
My lord.
It was not yet taken up. This matter was
It
not
is
yet
not
taken up.
not taken up, not taken up, not taken up.
On that day, it was a leftover.
Leftover.
No, any order was
Yes,
passed.
yes,
No order. was-
correct.
So we'll issue notice, let him
Copy
file
has
objection.
already been served, my lord.
So we'll
Yes.
record that.
Yes, ma'am. Yes.
And you are for?
I'm assisting the city.
Okay. Pardon, Mr. PJ Soikia, Lana Senior Counsel, assisted by Sen, Lana Counsel for the applicant. This is an application filed under section 528 of the. This is IA.
This is IA.
Bharatiya Nagrik Suraksha Sanhita seeking vacation, alteration, modification of the interim order dated 24/11/2025 passed by this court in criminal petition number 263/2025 staff. Issue notice since Mr.
S.K. Sharma.
Sushil Sharma, my lord.
Land Council appeared and accepted notice on behalf of the
Opposite party one.
respondent number
One.
1. And who? Okay, state and Miss Jeannie, are you okay, Jeannie, for the state respondent number
Yeah,
2 has accepted notice. No formal notice need be issued. Start. Mr. Sharma, Mr. Sharma, Lana Counsel for the Lana Counsel appearing on behalf of the respondent number 1 wants to file objection for which he how much time?
but 3 weeks or 2
For
weeks.
which
I don't know.
we praise for 3 weeks. Put in 3 weeks time.
3 weeks.
Prayer
3 weeks,
allowed.
3 weeks.
List this matter after 3 weeks. Okay.
Lord, yes.
May I pray, my lord, for a
In
date,
another
my
matter,
lord,
When?
In another matter,
my lord,
In
on
another
April
matter,
20
Lord.
April 20 again.
21st, my lord.
Oh, April 21st?
21st, my lord.
April
Lord, yes.
21st.
But this is not a problem.
Okay.
In the
As-
main case, my lord,
as requested.
in
In
the
the
main
meantime,
case,
my
my
lord,
lord,
Let this matter be listed on 21st April.
In the meantime, my lord,
Hmm.
I'll file, my lord, the affidavit. If so, my lord,
Okay, and the
and then,
and the
my lord,
applicant
endeavor
is
to,
also-
my lord, to dispose of the
App-
entire matter, my lord.
in the meantime, in the IA.
in the main, yes, my lord, in the
No,
main
no,
case,
no,
my lord,
no.
interim order to continue. In the main case, interim
Okay,
orders to
in the-
continue. About which the fight is.
Okay, in the main case, the Mr. No, Mr. Here would be Mr. Sushil Kumar Sharma, Halana Counsel for the petitioner. Also have Mr. PJ Soikia, Land Senior Counsel, assisted by Sanso for the you are correspondent number 1. Yeah, in main case,
In the main case, respondent number 1, 2.
1 and 2, and Miss Jenny for respondent number 3, state respondent number 3, staff, So in the main case,
It is, my lord, no affidavit is required. In fact, the
you are not filing.
assisting counsel, because it is a revisional jurisdiction, it will be based on the record. I cannot
Okay.
document anything.
The
can
record,
make this
whether the
statement.
record was called for.
Record.
Okay, okay, okay.
Record is already there.
So on that
Okay.
day, my lord, the application for I may be taken up or along with the, my lord, the same, my lord, the entire matter can be disposed of. My lord.
Okay.
Same
Since-
argument, my lord, for the I as well as the, my lord, main petition.
Since the parties are duly represented and the trial court record has also been received, Kamal, let this matter be listed for admission on 21st April. Okay.
My lord, there is an
Interim order to continue. My lord, interim order to continue.
The interim order passed earlier shall
Continue.
continue till then. Okay.
My lord, since record is here, my
I'm
lord, and endeavor to make, my lord. Yes, my lord, it-
Apparently, it's apparently, we'll try.
Sir, can I,
Hmm.
can I,
Okay.
can I request my friend to accommodate me in first week of May? First week of May, if you are there in some case here, in first week of May. Up to 10 or 11, whatever suits my friend.
Okay,
5th of,
okay. On the
Fifth of
request of the parties, list this matter on 5 May, 5/5/2026, on which date an endeavor shall be made to dispose of the matter. Okay.
Entire case, yes, bro. I'm grateful.
record is already.
Yes.
Okay.
Yes, bro. I'm grateful.
Item number 14 is a password matter.
Lordship, just I have gone through the records, Lordship.
Hmm.
Lordship, on 26/3/26, Lordship, notice was issued to both the accused person as well as the bailer, Lordship.
See, notice was issued.
Yes, Lordship, it is issued, Lordship. It was issued, Lordship, and on the
Well,
yes, Lordship.
okay.
And the Lordship,
See,
the
notice
order,
was issued.
yes, Lordship.
Then why you are submitting?
Which page?
On which date you said?
On dated 26/3/26, I have
The
black mark
present
here,
to appear
Lordship.
the accused examination to the accused person absent
Hmm.
absent with step. Absent without step. Land counsel and issued to submit a person not cooperating with him that is not appearing without any information issued and BW against the accused person and notice to bailer to bring the accused person.
Yes, Lordship, because this is the-
Notice to bailer.
already, Lordship,
not
he
for-
is, Lordship, he is already in bail, then no, bailer should be, the notice should be.
Okay,
issued
so
to bail-
non-bailable warrant of arrest
Yes.
was
Yes,
issued
Lordship.
against you. So it, so that is why you were taken into custody.
Yes, Lordship.
So then, see, then you,
Actually, Lordship, instead of coming in the criminal petition, Lordship, they should have come with fresh bail application, Lordship.
see, he was arrested in execution of the NBW issued against him. Then it's not connected with,
Not
I
to
think- you should file for the fresh bail application.
Yes, Lordship.
That will be better. We'll consider. But then cancellation, it will be difficult because you were arrested.
Lordship, in the
In execution
impugn
of the-
order,
in
in the
execution of
impugn
the
order, it is
NPW
reflected
issue.
that, in the impugn order, it is reflected that the bailer have brought the accused person to the because destroy a production of accused
See,
person.
are there also, you have
Otherwise
troubled,
produce-
you have already troubled the value more than once.
One of circular counsel.
And then Baylor repeatedly appeared before the court, it appears, and then expressed their difficulties that the accused is not cooperating, and Baylor
Baylor was
repeatedly
discharged
informed the
also,
court.
Lordship. Yes, Lordship.
Accordingly, your bail was cancelled.
Yes, Lord.
After cancelled, and then in execution of the NBW issued against you, you were taken into custody.
Yes, Lord.
You better file a fresh bail application. Will consider
Okay.
that your difficulties in appearing, and what was your difficulties in appearing, and then now you are going to cooperate. We'll consider.
Yes, Lordship. Because the accused habeas filed, minor file.
So that is why you take that grounds that due to all those reasons you could not appear, and then you had to go to Kerala, etc. only because of that problem. And okay, Mr. Pokan, G. Pokan, Lana Counsel for the petitioner, submitted. He uh, mm, wants to withdraw this criminal petition with liberty to file
First bail.
bail application before the trial court. Okay.
Not already trial court 2 times rejected by the court.
See, then after rejection, why you have
No,
come?
we-
November, in the month of November,
Oh,
because
that-
I am not engaged.
See,
in the
knowing that there is an order, notice issued, already issued against you, NBW issued against you on verbal query, you did not disclose that also. This will, see, Lani Council.
In the month of
that will
November,
be-
2
it will
times
be
bail
difficult.
application.
In that way, it will be difficult.
Yes.
Now, anything, every question or any submission made by you would be viewed differently. Don't do that. Never repeat that. With the liberty to file appropriate bail application before the appropriate forum. Okay, this criminal petition is dismissed with liberty to file. Liberty is prayed for. Okay.
God bless you.
Much obliged.
Item number 17.
My lord, on item number 17, ma'am, I have filed one unlisted IA for implement.
17.
Yes, ma'am.
17 is for
Passing of.
passing of FIR.
Respect of schedules of gestation case.
Just a minute. This is offense is under,
329-2, my lord,
what is this 329-2?
Criminal trespass.
Trespass.
against the DFO as well as the.
Okay, this say that case. And then you are, they are interim
Yes, madam, the investigation has been stayed by this honorable court on the last day.
investigation.
Yes.
Investigation.
Yeah, fine. And now, my lord, the informant has filed an application for impediment.
Okay, informant.
Yes.
You have not impleted informant. Today, actually. No?
There was a notification saying that any informant or any party is not preferred to be made as a party in criminal petition.
No, because here he was the informant.
My lord.
Okay. Will allow? Okay. In IA, huh? What is this? Another IA? Two IA.
Two IA, it's 17 and 18.
Oh, two different cases.
Connected with same. FIR.
Same FIR, your lordship. One is,
Oh, same FIR.
Yes.
one is the RF. One is the DA4. Item number
Okay.
17 is
17 is the DA.
Okay, heard Mr. H. Lampu, Land Council for the applicant. Also heard Mr. J. Sirinki, JT Key, huh? And Miss JT Key for the Land Council, JT Key, Land Council for the, but first then Miss Jeannie, huh? Also heard Miss Jeannie. Jeannie, Land additional, PP for the state respondent number 1 and Mr. JT Key for respondent number 2. Start, huh? Para. The respondent number 1 is filed criminal petition number 49 AP. This is in 49.
48.
48.
Yes.
We'll take up the 48 first.
48 first.
Okay, 48. Seeking passing of and setting aside of the FIR arising out of Sijosa police station case number 2026 under section 3292 within bracket 2 of BNS 2023. Stop. By filing this without impleading the informant, a respondent party. Stop. By filing this application under section 528 of the. This is also 528. Implement 528. By filing this application, the informant seek his implement in the aforesaid criminal petition number 48 FU 2026. Being the informant in the case. Stop. The prayer for implement has not been objected to by the Lana Council appearing on behalf of the respondents. Stop. In view of the above, this application is allowed. Stop. Let's Mr. Srimati Yari Navam. The applicant be impleaded as the respondent number, respondent number 3. Two in criminal case. Okay, in criminal petition number 48 AP 2026. Stop. Okay, then in the main, So what order is to be passed here in today? It is listed. You have taken steps
Yeah,
against,
we have,
because there was no other party other than the state.
yes,
Now he's appearing.
Yes.
You want to file objection here.
First,
Impleaded, we'll pass that order. After that, okay, then
copy of
Mr. JTK, Lana Council for the applicant, sorry, petitioner. Also had Mr. Gini, Lana Council appearing, Lana Council, Lana additional PP for the state. Stop. Para. In view of the order passed today in IA number 20, AP 2026, Srimati Tenso. Please implead, Yari Navam, wife of Takam Navam, Takam Navam, EOPS Joseph Kesaha, District Arunachal Pradesh, impleaded as respondent number 2. Stop. 2. Stop. Then it is to be amended or
Yeah,
just
yes.
inserted? Okay,
no, Your Lordship.
the petitioner shall file amended course title.
Lordship,
Amend the course title, And then file amended course title by impleading, by inserting the newly impleaded respondent number 2. Stop. The registry shall do the needful. Okay.
Your Lordship, I'll just, I have got the CD. Your Lordship may call for, on the next date, Lordship may call
Okay.
for the updated CD. There's a small prayer by me, Your Lordship. On the last occasion when the interim was granted, the court has clearly stated that no coercive action will be taken, Your Lordship.
Yes.
I just wanted, if Your Lordship could elaborate, because investigation has not been stayed, only
Yes.
coercive action.
Investigation can be, and he or she can be called for
only
recording
not
statement,
harass-
everything except arrest.
Arrest
No, no,
and
no.
harass in any.
No, my lord, no coercive action as such, there's no order as such. The FIR has been specifically stayed until further orders, my lord. I have the copy of the order, my lord.
FIR state,
Yes, my lord.
No coercive action.
No coercive action is stayed. Until further order, my lord. Last one. The FIR has been stayed until further order, my lord.
no, how in the interim, FIR arising out of Pijosha
In fact, today I.
Now, if the FIR state means
Yes,
it's
I
difficult.
have in fact got the CD also, and there is a specific prayer by the IO that let the investigation proceed.
No,
In
But
fact,
FIR stay.
no,
would
my lord,
be-
I have a very strong case, my lord. This FIR has been filed in retaliation of my FIR, only to neutralize the lawful official function, my lord.
Okay,
And the
okay,
section-
you are the officer
Yes, my
Yes.
lord. I
who
have
issued
filed it.
so cause notice.
no, no so cause
There was
notice
one
was
show cause
issued.
notice also, but that is not related.
And
to
you
the
are?
issue. I am the DFO in this case.
Okay.
I have filed an FIR. I have been assaulted. By
Okay.
the
I-
president
Yeah, he is a
government.
here, there was a,
No, no,
probably,
And they have
I'll-
there
moved
was
an-
no case
No,
Yes,
I
my lord.
know.
against her.
I'll just apprise your lordship.
Hmm.
On that particular day, your lordship, police was also there. As per their FIR, they had gone to a certain place getting an information that there was an illegal cutting of the timber.
Yeah,
your
so
lordship.
they visited.
No, not to that place. Then on their way, they stopped here waiting for the RFO, who is the applicant in item number 18.
Hmm.
While waiting, what they did is, I have, in fact, this CD is there. I have the photograph. If your lordship just peruse it, CD and the video, your lordship. Now what? It's there is.
Well,
this
in
is
that
the-
case, it has to be heard on merit, madam, on full-fledged hearing, madam.
Reason because your lordship is
Absolutely.
concerned about the interim, your lordship.
Hmm.
This is the ADC's office, your lordship will see. This is the, your lordship will see that this is the ADC's office. Now when
The photographs.
these are the photographs. That are the photographs, your lordship. That photographs, your lordship will see green building, green. There is a roof, green roof. That is
Yes.
the ADC's office.
Okay.
Now the construction is happening in that part.
Now, in the front, there is a road, there must be road.
There is a road.
Yes.
Yes, then,
There is a road. Your lordship will see that.
so they kept the gap.
No. Therefore, I was coming. Your lordship will see the video in the pen drive also, that what the officials did without giving any notice, neither prior intimation, neither calling upon the magistrate, which is who.
It's not required, madam.
Which is mandate.
It's not required.
Which is
Under
mandate.
the Assam Forest Act,
If
madam.
it's a mandate, then I'll just
I'll show
explain
the
it.
record. I'll
just
show the-
explain. It's
Okay.
just a price,
Okay.
not to this. Now, what has happened was that your lordship will see the video given in the pen drive, that the police officer shuttering was happening, and the police, the DFO and the RFO personals has demolished the shuttering, took out the bamboos, and then they did not even seize it. They kept it in the road itself. Neither seizure was made.
This-
Now,
Either-
this probably
Now-
the duty of the magistrate.
Yes, madam.
Hmm.
Magistrate is altogether different, madam, giving show cause notice. While they were on the way, they have found that there were some,
You are
Suspicious-
concerned with the bamboo.
yes, madam, suspicious bamboo and wooden planks. So we
Okay.
went there, we have verified it,
Okay,
and there was
so-
someone who was the owner. Then we have,
But then if it is regarding the eviction, then
that's altogether
the
different issue, my lord.
DFO would be
Yeah, my lord.
not the proper.
But so far, the Assam Forest Regulation, my lord,
Hmm.
I'm empowered to do it. Without the
Okay,
warrant, even
so
I can
that
arrest
may be
also, my lord.
different, because
Hmm.
in that case, what I have seen in the FIR also, that it was concerned with the DFO
Different-
is concerned with the
different-
bamboo.
No,
Illegal,
different. He has got an
If it is
information
different
that,
location, I have
Yes.
no idea.
no, not different occasion, your lordship. He has got an information that there were illegal cutting of timber
Mhm.
in a NAC road. Now, while going to the NAC road, they made a stop at the place of occurrence, your lordship. They did not even go to the NAC road where they had got the information for about the cutting of the timber. In fact, they stopped in this place, which is
Okay.
A2 road, not even an
Anyway,
NAC
so
road.
you file objection.
Your lordship, because my filing of objection would be enclosing of the entire CD, which ought to be confidential.
yes.
Therefore,
Okay,
on the next
okay.
day, I'll just produce the CD, your lordship.
Okay. Then in the other case also, implement would be the same. Okay, then in the main case, you're right, huh? Mr. J.T. Kilan, counsel for the petitioner, he is present. Ms. Tijini Lanet, additional PP for the state. He is also present, and then you are not going to file any objection.
Your lordship, what I'm trying to say is, even if I file the objection, your
Hmm.
lordship, since I'm relying on the CD cannot be annexed along with the petition.
Okay.
Since it's a
So,
confidential, so I'll
but-
be
but
relying
then
on the CD.
This is, what is this then?
CD, your lordship.
This is CD.
This is prior to when the stay was given, your lordship.
Okay. Okay. So only CD will be produced.
Only CD will be produced.
Okay, is also present, huh? Hmm. So your name will be reflected only after amendment of the course title, when your name reflects.
Yes.
Okay. Hmm. Okay,
In the meantime,
okay. Since oh, then in the meantime, the petitioner shall furnish a copy of the criminal petition, a copy of the petition to the land council, the newly impeded. Land council for the new land council for appearing on behalf of the newly impeded respondent number 2 within 3 days
Right.
from today. Okay. Then that next also same,
Same.
similar order.
Same order.
Okay. In the IA also, that's just number will change. Okay. Similar order. Then the IA stand dispose upon both the IA. Okay.
And this matter will be,
Listed
And then when this matter to be listed,
that will be on the 3rd of
April.
23rd of April, as requested by the parties. Let this matter be listed on 23rd April.
Your Lordship, on that same day, my CD may be produced again. Your
Okay, on which date the Lanet additional PP shall produce the updated case diary? Okay.
Did-
Hmm.
grateful.
Matter number 20,
Your Lordship, in this matter, I don't know why was it fixed for hearing, because it has not been admitted, Your Lordship. It ought not to have been listed in the hearing matter. This is,
It should have been in order.
yes. In fact, if a legal aid counsel is being appointed, and because there is no petition to
Hmm.
a proper format of petition be made, you know.
Legal aid counsel also not yet appointed.
Yes, I don't know why was it, why is it fixed for hearing? On the last occasion, only the TCR was called for, Your Lordship.
TCL received, no?
Yes.
Okay. Ms. Tijini, Lanet additional PP4, the state. Stop. The trial court record as called for has been received. Stop. Since this is a jail appeal, this court should deem it appropriate to appoint one legal aid counsel to represent the appellant. Stop. Accordingly, who, this is OXO case.
Your Lordship.
Lampu, you are also a legal aid counsel. Enlist.
SB Darang is there, Your Lordship.
SP Darang. So why don't you enlist? Because you have to do some at least pro bono also to the court.
I mean, amicus.
Amicus, but then but amicus, but for defense side, it's only a legal aid counsel. They are at least
Regular one.
I will mind. Next time.
enlist yourself, huh? Because every time we find that this legal aid counsel not appearing.
Yes.
And some advocates who regularly appear, we are not able to take their service.
Yes.
Okay. Miss SB Dara. Panel legal aid counsel is appointed as the legal aid counsel to represent the appellant. Staff. The registry is directed to furnish a copy of the judgment.
Yes.
And what else? The other will be
No, other will be after her appearance.
after her appearance only. Stop. To enable her to enable the legal aid counsel to prepare. There is a appeal memo.
There is no appeal memo.
Okay, to enable the legal aid counsel to prepare a memo of appeal. Is there any delay?
Your Lordship, there is a delay. There is a delay, your lordship, but
Judgment was passed on 6/25. I think there is a delay.
yes, and
Okay, and also the delay continuation petition, if any.
yes,
Okay. Stop. List this matter. List this matter
after 2 weeks, your lordship.
after 2 weeks. Okay, let her appear.
Yes.
In list matter after 2 weeks in order column.